for pronouncement of judgment, item number 1.
In the result, the present petition is partly allowed. The conviction and sentence under Section 8 of the POCSO Act is quashed and set aside. However, the conviction under Section 354A 1 of the IPC and the consequent sentence is upheld. It is hereby directed that the accused shall be released upon serving out the sentence under Section 354A 1 of the IPC. Rest of the pages are signed.
Your Ladyship, please, Your Ladyship. Ladyship, I'd like to mention item 29. Item for the state here. I'm yet to receive instructions, so allow me 2 weeks' time so that 29.
Which one? 29.
Yes.
No objection?
No.
3 weeks.
3 weeks.
Learned Government Advocate Mr. Moingchen prays that he is yet to receive instructions and accordingly prays for 3 weeks' time. Stop the prayers aloud. Learned Counsel for the petitioner, Sri Sarnisach, is present. His list after 3 weeks. Yes.
Much okay.
May I please, my lady? My lady, I'm appearing for VC, my lady.
Yes.
My lady, I would like to mention item number 8 and hearing item number 36, my lady. My lady, as per the last order dated 2022, my lady.
Yes. Item 8.
Yes, item 8 and item 36, my lady. On the last occasion, there was a confusion as to who represented the company.
Oh, yes,
So,
yes.
Yes.
So
my
clarified
lady,
now.
yes. I would withdraw my wakalatnama
Okay, in both.
in both the cases, my lady.
Item 8 and 36, okay. Learned Counsel, Mr. Vikramjit Devnath submits that, prays that he may be allowed to withdraw his Vaklatnama for the respondents.
Yes, in item number 36, it's for the respondent, and item number 8, it is for the appellant.
In 8 it is for the appellant, and in 36 is for the respondent, okay. The prayer is allowed. So, in 8 you say, Learned Counsel for the respondent. In 8, Mr. Imtiwapang is present.
Respondent number 1.
Okay, when do we fix it then? So you'll be the new counsel?
Yes,
Okay.
Your Lordship. If the matter can come up after 3 weeks, Your Lordship.
Learned Counsel, Ms. Kim Penyu has entered appearance for the appellant and prays for 3 weeks' time. List after 3 weeks. Then in item 36, Learned Counsel, Mr. Inti Wapang is present for the appellant.
Lodge.
And when would you like?
After
Item
3 weeks,
36.
Your Lordship.
And prays that the matter may be listed after 3 weeks. So, Learned Counsel, Ms. Kim Penyu enters appearance. Have you filed a Vaklatnama?
I have sent a Vakalatnama to the company to be signed.
Okay. Learned Counsel, Ms. Kim Penyu submits that she will be entering appearance for the respondent insurance company and submits that she has sent the Vaklatnama for signature and accordingly list the matter after 3 weeks. Yes. Please.
No problem.
Yes.
So I beg to mention item number 19, contempt. Mr. Pierre, I'm yet to file a Vakalanama and obtain the instruction. 3 weeks' time will be granted. I'm for the respondent number 2, Home Commissioner.
Okay. Learned Counsel, Mr. Im Tim Song submits that he will be entering appearance for the respondent number 2 and prays for 3 weeks.
3 weeks.
Time
And to file Vakalanama.
to file Vaklatnama and to receive instructions. So, Learned Counsel for the petitioner, Mr. Sarnisach is present and has no objection. Learned Counsel, Mr. N. Angami appears for respondent number 1. So, list after 3 weeks. Yes.
Lordship, item number 20 is saved. It's analogous.
Okay, here also R2.
Yes, Lordship.
Same order. Yes. And in 20 also you are appearing for R1. Okay, yes, same order. Yes. After 3 weeks, both 19 and 20.
Lordship, and the item number 20, we are for respondent number 3, Your Lordship.
Item 20.
Yes.
Ms. Kim Penier is
Appearing on
present-
behalf of my senior and Longkumar, Your Lordship.
is present for respondent number 3. So 3 weeks, after 3 weeks,
Yes,
you
yes,
file your
Your
affidavit.
Yes.
May I please, Your Lordship? Lordship, I beg to mention item number 15, Your Lordship. Lordship, I'm for R2, Lordship.
No, I have some objection. We have filed an IA in this case. So let this matter come, then your lordship can
IA
take
for?
it on. IA, we have come additional affidavit. We have filed an affidavit in this case.
Okay.
They have nothing
Just-
to do with
just
them.
wait.
They have nothing to
Yeah.
do with my learned friend. It is what we brought notice to the court, cooperating all the investing. We have given a detailed manner. Let it come, man.
Let it reach.
May I, Your Lordship? In item number 19, we are for respondent number 3, appearing on behalf of my senior and Longkumar, Your Lordship.
19 is already mentioned.
Yes, but
Both 19.
since it,
Okay, in 19 also,
Same.
M. Nongkumar appears for respondent number 3.
yes.
Yes.
Bless you.
Yes.
Let me mention item number 23. Lordship, let the matter come after 3 weeks. And for respondent number 1,
3 weeks for?
to file affidavit.
Learned
Lordship,
counsel.
in this matter, respondent number 2 and 3, service report is still awaited, Your Lordship.
Learned counsel, Ms. Kim Penier is present for the appellant. Mr. Your name?
That's all here.
Nangsang Iyer submits that, prays that he may be given 3 weeks' time to file the affidavit in the present case. Prayer is allowed. So, learned counsel for the appellant submits that the service report on respondent number 2 and 3 is also awaited. So, list after 3 weeks.
The black.
Please, Your Worship.
Yes.
Your Worship, I beg to mention item number 18. Order.
18?
Yes, Your Worship. Your Worship, I have received the paper publication, so I may be allowed 1 week time to file my...
You file by way of affidavit?
Yes, 1 week time may be granted.
Learned counsel,
Lordship,
yes.
3 weeks, Lordship, since I'm also yet to file the objection.
Learned counsel, Mr. Z. Kovno for the appellant submits that he would like to file an affidavit, a compliance affidavit with regard to the notice served by way of a newspaper publication and prays for 3 weeks' time. So, learned counsel, Mr. Inti Wapang, appearing for the
Respondent number 1.
respondent, also prays for 3 weeks' time to file his objections. Objections? Yes, list after 3 weeks.
Much obliged, Your Worship.
Obliged, Lordship.
Yes.
May I please, Lordship? Lordship, I'd like to mention item number 34 from the hearing list.
34.
Lordship,
Yes.
the leading counsel has some personal difficulty today, my lord. So I've taken consent from the other party also.
Only your name is there.
Yes, the leading counsel's name is not reflected in the cause list. His name is,
You have forgotten his name. You supplied the name later.
Yeah, okay.
Learned counsel, Mr. Medu Vero, submits that the leading counsel, Mr. Such and Such, has some difficulties today since he's an outstation lawyer, and prays that the same may be listed
on 24.
on 24/3. So, the prayer is allowed, list on 24/3.
Much obliged, Lord.
You supply the name?
May I please, my lord?
Yes.
Lordship, I beg to mention item 24. I am representing respondent number 1 in this matter, Lordship. If 3 weeks' time can kindly be granted to receive the necessary instruction, my lord.
Yes.
No
No objection. Present counsel for the petitioner, Ms. Sajantar, present. So, learned counsel, Mr. N. Angami, appearing for our respondent 1, prays for 3 weeks' time to receive instructions. So, prayer is allowed, list after 3 weeks.
I am deeply obliged, my lord.
My personal lady.
Yes,
I'd
Mr.
like to mention item 21. In 21, we find the reply. And but service upon respondent number 1 respondent is still awaited. The private respondent. Informant. And
How did you take the steps?
we've taken through post through the registry. We've taken twice.
Why don't you serve through the jurisdictional PS then?
Yes,
The
yes.
police station, that's
Yes.
better.
Yes, my
Learned
lady.
counsel for the petitioner, Mr. Foseko, so they submits that the service report on the informant is
Number 8.
respondent number 2, na?
8.
8, respondent number 8/informant is still awaited. He submits that he has already taken steps for service twice. However, the same is not returned. So the petitioner is permitted to take steps on the respondent number 8/informant through the concerned police station. So, Learned PP, Miss S. Mary is present and has no objections. List after 3 weeks. Okay.
Lady, can we come up on the 20th of April? Since it's laid by my senior Mr. P.B. Toddy, Dr. P.B. Toddy, so
Okay,
can
then
come up on
that last line.
20th of April.
Just say Learned Counsel Foseko submits that the leading counsel, Mr. Such and Such, is an outstation lawyer and therefore prays for listing the matter on 20
April.
20
April.
20th April. So list on 24 2026. Yes.
Lady, my lady is in interim. Can let the interim
The
continue?
interim order passed earlier shall continue till the next date.
Hello, plus.
For motion, item number 2.
Now it's done.
Now it's done, Your Honor. Page number 3.
Okay, we'll issue notice.
Madam.
The instant application under section 438, read with 442 of the BNSS, has been preferred against the impugned judgment and order dated 25/4/2025, passed in criminal appeal number 1 of 2024 by the learned Principal District and Session Judge Mokokchung. The petitioner has also assailed where is that?
Chief Judicial Magistrate.
Wait. Assailed the judgment and order dated 9/4/2024, passed by the learned CGM Mokokchung in GR case number 105 of 2021. Paragraph learned counsel for the petitioner, Mr. Medovero. So the learned counsel submits that grounds, where are your grounds?
Page number 8 of my criminal revision petition.
Page 8.
Yes, my lord. Paragraph number 10.
Submits that the conviction of the accused in the present case was illegal and not in accordance with law, inasmuch as there was no medical report, photographs, and no direct documentary evidence. Stop. And the case has not been proved beyond reasonable doubt by the prosecution. He has also submitted that the trial courts did not examine, the trial court as well as the appellate court did not examine the procedural lapses which were committed by the prosecution, especially in respect of section 161 and 164 of the CRPC. So, issue notice returnable in 4 weeks. So, the petitioner shall take steps for service on the respondent number 2 by speed post as well as usual process within 3 working days. Mr. Tipapom, learned public prosecutor, has accepted notice on behalf of the respondent numbers 1 and hence no formal notice is called for. Do you need extra copy?
No, my lord.
Call for the records of the GR case number 105/2021 from the Court of Chief Judicial Magistrate in Pokchung, and also the records of Criminal Appeal number 1 of 2024 from the Court of Principal District and Sessions Judge released after 4 weeks. That's all?
Yes. Much well, sir. Much obliged, Your Honor.
Item number 3.
Hello, I am appearing in this matter, hello, on due, my lord. It is an application under section 482 for quashing of the criminal complaint, my lord. And now, this is a matter, my lord, relating to drugs. My lord, it's drug, my lord, Drugs and Cosmetics Act under medicine. So this medicine was originally supplied to another party, my lord, that is Morpem Laboratories Limited, and Morpem supplied it to Director of Medical Services in government. Now, the sample was taken in the district hospital, Dimapur, my lord. Now, the sample was sent to the for analysis. If your losses turns to page 26, my lord, and it's a 2 analysis report.
Page
26. Well, date of receipt. If your loss receipt is number 4, item number 4. Item number 4.
Yes, 16/4/21.
16/4/21. Now, in the bottom, my lord, you will also find date of testing. 5/8/21, 13/8/21, 31/8/21. These all these dates are there, my lord.
Yes.
My lord, as per Rule 45 of the drugs rules, my lord, drug is to be tested within a period of 60 days, my lord. If you also will see the drug rules, my lord, Rule 45.
Drugs and Cosmetics. This is 4, 5, 6, 7, 8. After 4 months, testing was done after 4 months.
Yes, my lord, after 4 months, my lord. But compulsory it is, my lord, 60 days. If you also see.
Rule number?
45. Rule 45. That page in the book, main book is 76 page. I don't know which book it is.
Yes.
Yes. The government analyst shall cause to be analyzed or tested such sample of drugs as may be sent to him by the inspector or other persons under provisions of chapter 4 of the Act, and shall furnish reports of the result of test or analysis in accordance with the rules within a period of 60 days from the date of issue sample. So report is to be submitted within 60 days. Here report has been given on 16/9/21, my lord. After 5 months. And that provided, my lord, there is provision also, my lord. They can take permission, my lord, if it cannot be, my lord. Provided that where it is not possible to test or analyze the sample within a specific period, government analysis will seek extension of time from the government by giving specific reason for delay in such test analysis. So they have not, my lord, done anything. They have, my lord, tested it after 4 months, and then report was submitted after 6 months, 5 months.
Okay.
So, well, this is one of the flow. Secondly, my lord, on that basis, the complaint was lodged in 23. If you also see page 26, my lord, the after item number 5, the base number, you also got it, my lord, base number.
This name of the sample, batch number.
Yes, the name of the sample, then base number, manufacturing date, and April 23.
Expiry date, April 23.
23. Now they have filed a complaint in 23, and cognizance was taken. My lord,
Where is that? Where is the complaint?
At page 39, my lord. And cognizance was taken, my lord, if you also turn to page 53 on 11/11/25. on 11/11/25, my lord. And on that day, process has been issued, my lord. Director. Now here, 3 flaws are there, my lord. First thing, I could not pay for analysis of sample by the central laboratory because by the time the drug has expired, my lord. Secondly, my lord, the learned trial court, now as per provision of section 223, before taking cognizance, notice must be issued to the accused and he must be heard, my lord. Secondly, we are from outside, my lord. Outside, so 225, my lord, also there should be an inquiry.
Inquiry was not done.
Not done, my lord. Here. No witness has been examined, my lord, here. And fourthly, my lord, there is no allegation that the petitioner number 2 and 3 are in state of affairs of the that unit, my lord. Because the complaint is against the unit, my lord, not the company. We are the managing director of the company. There are many units. So some allegations are there against the 4 and 5. But so far, accused number 2 and 3, no allegation, my lord. We are not, 4 and 5, we have not applied for crossing, my lord.
Okay, we issue notice at this stage.
Further proceeding may be stayed, my lord.
1 minute. Have you served notice on respondent 1?
No, yes. Just a minute.
Respondent 1, who's appearing? CJC is here. CJC, have you served notice?
Yes, I have served.
The present application under section 528 of the BNSS has been preferred by the petitioners. Praying for quashing of the proceedings of complaint case number 2/2023 pending in the court of Chief Judicial Magistrate, Dimapur, Nagaland. And also for quashing the order dated 11/11/2025, 11/11/2025, passed in the aforementioned case, by which process has been issued against the petitioners. Stop. Learned Senior Counsel, Mr. G. Sahiwala, Senior Advocate, assisted by
M. Sayola.
Sahiwala. Stop. The case of the petitioner is that the section 45
Rule 45, madam.
Rule 45 of the Drugs and Cosmetics Rules 1945 mandates that the analysis of the drugs has to be done within a period of 4 months. Is it? No,
60
within
days.
a period of 60 days from the receipt of the sample. However, the Form 13 under Rule 36, by which the certificate of test or analysis by the government analyst was given, and which is annexed to the petition, shows that the date of receipt of the sample was received on 16/4/2021. However, the date of testing was on 5/8/21, 13/8/21, 31/8/21, 1/9/21, 7/9/21, and 10/9/2021, i.e. after a period of 5 months. Stop. The learned counsel submits that the proviso also provides for the government analyst to seek extension of time from the government giving specific reasons for the delay in such testing or analysis. Stop. However, the said permission was also not sought by the government analyst. Stop. Another ground taken by the petitioners is that the complaint was lodged only in 2023, and further the learned trial court took cognizance of the matter by the order dated 11/11/2025 without conducting any inquiry before issuance of process as envisaged, as mandated under the CRPC. As the petitioners are living outside the territorial jurisdiction of the learned Chief Judicial Magistrate Dimapur. Stop. Issue notice returnable within 4 weeks. Stop. The petitioner shall take steps for service on the respondent number 1 and 2. For
one already served,
yes,
we can serve another go.
Yes, on respondent number 2 by speed post document as well as using access within 3 working days. It is stated that the notice on respondent number 1 has been served on the learned CGSC. Stop. List after 4 weeks. In the meantime, it is directed that the further proceedings of complaint case number 2 of 2023 pending before the learned CGM Dimapur shall remain suspended till the next returnable date. Yes.
Any date may be fixed, my lord. Any date may be fixed.
4 weeks.
Well, my lord, because I'm outside, my lord, so any date may be fixed.
After 4 weeks, you give a date.
Yes.
Please. April 9th.
9th April.
9th April. Yes.
Item number 4 and 5.
Yeah, please, my lady. My lady, is an application for withdrawal of the 50% of award being deposited before the registry. The claimant has authorized its counsel on the matter that
It has been deposited.
yes. So if the lordship places if the amount may be released to the
objection?
claimant.
No.
The instant application has been filed by the petitioner / applicant, who is the respondent number. You are respondent number 1 in the main appeal.
Yes.
It's the respondent number 1 in the main, in the connected MSc appeal 20 of 2025. Stop. The present application, in the present application, it is prayed that the applicant may be allowed to withdraw the 50% of the awarded amount which has been deposited before the registry of this court in compliance with the order dated 15/9/2025 passed in MSc appeal 20 of 2025. Stop. Third learned counsel for the applicant, Mr. Foseko Fati. Stop. He has submitted that while suspending the order impugned, judgment and award dated 15/9, impugned judgment and award dated 16/6/2025, passed in MSc, what is the main MSc number?
20.
No.
MSc
36 of 2023.
MSc 36 of 2023. Stop. This court had directed the appellants / insurance company to deposit 50% of the awarded amount before the registry of this court within 2 months. Stop. In compliance, the appellant slash insurance company has deposited the 50% of the awarded amount on 27/2/2026. It is therefore prayed that the applicant may be allowed to withdraw the amount which has been deposited before the registry. So the court has, this court has considered the pleadings and also gone through the authorization as well as the order dated 15/9/2025 passed by this court. So it is also seen that where is the check? The appellant insurance company has submitted a check bearing number 006037 dated 27. Oh no, sorry, that is your statutory deposit. Do you have the details of the check deposited? It is not here. Okay, anyway, you delete that. You just say, the learned counsel for the appellant insurance company, Ms. Kim Penyu, is present and she has no objections to in the present application. So accordingly, the petition is allowed. The registry shall release the deposited amount of rupees, how much?
28 lakhs.
Amount of rupees 28,78,000 to the applicant slash this Naresh Mahato.
Naresh Mahato, Lordship, as per the Annexure B, page 11, he has authorized the council to withdraw. If it pleases your Lord, my lady, if you can pass orders.
Where is that?
Page 11 of my application. Naresh Mahato is authorized. Since the claimant is disabled, he's the person who is, he's the brother of the.
Who is this Naresh Mahato? He's not the applicant, and he's not the respondent also.
He has been authorized.
I, Shri Naresh Mahato, son of such and such.
Represented by his brother, Mr. Shri Naresh Mahato.
No, the authorization has to be by one of the respondents. This person, Naresh Mahato, is not a respondent.
Not a respondent, but
Not a
he's
respondent.
representing Mr. Lal Babu. Mr. Lal Babu is in a vegetative state. So even in the main court below, he has represented Mr. Lal Babu. %90 disabled. The claim was filed by Mr. Naresh, representing his brother.
Represented
Yes.
by his brother, Shri Naresh Mahato.
So now, since he's unable to come up, since he's taking care of this victim, the injured, he's authorized the council.
Last line, what did I say? Of rupees such and such, na? To the council for the applicant who has been authorized by Shri Naresh Mahato, the representative of the respondent number 1, is it?
Yes,
Respondent
number
number
one.
1/victim. Respondent
claimant.
number 1/claimant. Stop. The registry shall duly verify the identity of the council as well as Shri Naresh Mahato and thereafter release the same. Yes. You give the identification papers of the Naresh Mahato also.
Lord,
Petition is
my lady,
disposed.
my
Yes.
lady. Hello, buddy.
For admission, item number 6.
May it please your ladyship?
Yes.
Your ladyship, I have filed my affidavit on preliminary objection this morning, lordship. Copy duly served to the opposite
Preliminary
party.
objection.
Yes, your ladyship.
I've received a copy.
Yes. So do you want to file any reply or anything, or should we hear
It
you
can be fixed for hearing on Monday
Monday?
on the preliminary objection raised.
Learned Counsel, Mr. Moore Jamir is present for the petition, for the appellate. Stop. Learned Counsel, Mr. James Newmai, appearing for the respondent. Sole respondent.
Sole respondent.
Sole respondent submits that he has filed an affidavit of preliminary objection in the present case. So, Learned Counsel for the appellant prays that the matter may be listed on
16.
Monday will be on 16/3 for hearing on the preliminary objection. Stop.
Your ladyship, may it be admission hearing?
Yes, admission hearing. It's an admission in any case, yes.
Yes.
For admission hearing, no? List on 16. Yes.
All right.
Item number 7.
My lord, in this matter, I am little busy today. May I request for a short adjournment? I have about 20 matters in the Supreme Court today. It will be not possible for me to argue the matter today.
My lord, there are 3 matters. Item number 7, item number, my lord, item number 11, and item number 30. 30.
Item 30.
Item 7, 11,
7,
and 30.
11 and
30.
7, 11.
7.
These are all
Seven.
related.
Yes, why? 7 is the complaint where we ask for quashing of the complaint. Charge it. And
I'm only asking for a date. I have to go to another
we are
court.
not-
That's all.
I'm not arguing the matter, I'm explaining to the court what the ladyship is asking. 30 is a predicate offense where we have put to challenge. The ED has filed an
No.
application.
What I'm trying to say is it has to be heard together, isn't it?
Yes, correct.
All 3.
Yes, correct.
So-
Right. And in item number, my lord, 11, there is an interim order which will continue.
We'll
Yes,
extend-
that can be extended.
Yes, 11.
So, Learned ASG, when would you like it?
My lord, there is a
Just
date
give me a minute.
convenient on 6th of April, that is on Monday, my lord. If it is convenient to my learned friend Raju, 6th of April.
7th would be more convenient, but 6th is also.
Monday, I can start.
6th is all right.
6th.
Very good.
Because Mr. Das
But
is also
now-
coming
now-
from Gauhati, so.
Yes, now
we
one
can-
thing is there. In so far item number 11 is concerned, we have, the copy has not been served to us. Why?
What copy?
The copy, they have filed an affidavit. Objection they have filed.
okay.
They have filed an objection on 9th. 10th of February matter came up, but there was some defect in registry. And my learned friend who was appearing, he is with me, and the ED council said that we'll serve the copy. But till today we have not been served.
We'll ensure it is served.
Yes.
Please serve it before the next date.
Yes.
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 Okay. Item 7, 11, and 30. Okay. Senior Counsel, Mr. D. Das is present for the. You are the petitioner in all.
I am the
these
petitioner in all these cases.
petitioner.
If
Assistant.
Mr. Das, instead of 6, can it 13th be all right? 13th?
13, there is holiday which starts. Our holiday starts BU holidays.
Yes, BU
so,
holidays.
so let it be on 6th. We will see it on 6th.
Very well. Very well.
Yes.
So, Learned Counsel, Learned Additional Solicitor General, Mr. V. Raju, is it, says that he has some difficulties today to argue the matter, and therefore prays for listing the matters on 6th April, okay, 6th April 2026. So list accordingly. Stop. And then in 11 you say the interim order passed earlier shall continue till the next date. Then Also in 11, you have not received that.
11 I have not received.
Then in 11 again, you say, learned senior counsel further submits that he has not received a copy of the additional filed by the enforcement directorate. Stop. The enforcement directorate shall ensure that the copy is served on the learned senior counsel petitioner before the next fixed date.
What he's referring to a counter affidavit, not additional affidavit, my lord, counter affidavit.
You make sure.
We say objection here, but they use.
They are saying counter affidavit, so let it be counter affidavit.
Indian interim order will consider, will
Yes,
continue.
yes, only in 11, isn't it?
Only in 11,
yes. Yes, already.
Oh, grateful.
Okay.
Deeply up.
Item number 10.
May I please, Lordship? Lordship, this IA 154 is an application claim for staying of the operation of the impugned judgment order dated 23/5/2025, my lord, passed by the 11th Motor Accident Claim Tribunal, Dimapur, Nagaland. Lordship, I pray that the appeal may be admitted, my lord, and that the impugned order may be stayed in this case.
May it please your Lordship. Lordship, the appeal already admitted by order dated 18/9/2025, Lordship.
18/9.
Lordship.
Yes, already admitted, and we've
Lordship.
called for the trial court reports also.
TCR has been called on
TCR
18/9/25.
has also come.
Lordship.
We'll hear it then, and then we will stay. And we'll listen for hearing. Heard learned counsel for the appellant, Mr. Medovero, also heard Mr. Imti Wapang for the respondents.
May it please your Lordship.
Yes.
The IA may be stayed.
Yes.
Subject to the
Yes.
deposit of the
Yes,
50% of the
50%.
Yes. Lordship.
This will be in the IA, okay? Learned, you say Medovero for the petitioner, and also Mr. Imti Wapang for the respondent. The instant application is been filed, praying for stay of the operation of the impugned judgment and order dated 23/5/2025, passed by the learned member MSCT Dimapur, Nagaland, in MSC case number 215 of 2016. Stop. Learned counsel submits that the applicant has preferred an appeal against the judgment and order dated 23/5/2025, and the same has been registered as MSC appeal number 17 of 2025. Stop. He submits that the appeal has been already admitted for hearing, and that the appellant has taken good grounds for appeal, and there is every likelihood that the said appeal will be allowed. And it is therefore prayed that the impugned judgment and order dated 23/5/2025 may be stayed during the pendency of the appeal. Stop. The learned counsel, the court has considered the submission of the learned counsel for the applicant, and in the interest of justice, the impugned judgment and order dated 23/5/2025 is stayed subject to deposit of 50% of the awarded amount by the applicant/appellant within 30 days, within 60 days.
2 months, madam.
Within 60 days from the date of this order.
May it please your Lordship.
Yes.
I'm sorry for my indulgence. Upon the deposit by the appellant, the claimant may be allowed to withdraw, Lordship.
You file an IA after that.
Lordship.
Okay, after what did I say? Within 60 days from today. The application is allowed and disposed. Okay, and in the main appeal, you say the trial court records have been received. So please the matter for hearing after a month.
After a month.
After 4 weeks.
Obliged,
Obliged,
my lord.
Item number 12.
Please, Lordship. My Lord, the present application, the present IA is filed, praying for a continuation of delay of 564 days in filing the recalling application. If my Lord may kindly come to page 10 of my IA 35. Page 10, that is the last page.
IA 35.
IA 35.
Yes.
This is the order by which the appeal was dismissed on default.
Page?
Page 10.
Okay.
Page 10. My Lord, is my Lord there? I may be allowed to read out. Dated 8/8/2023, Mr. Such and Such, learned counsel for the claimant, respondent number 1 is present and mentions that the respondent are pro forma respondents. The learned counsel also submits that this court order dated such and such shows that notice to the appellant has been delivered. However, the appellant has failed to appear on the court date fixed on 18/7/2023 and have again failed to appear today. Thus, considering the fact that the appellants have failed to present on the court date fixed in spite of received notice, this court finds it fit to dismiss the appeal on default for non-prosecution of the case by the appellant. Accordingly, MEC Appeal 2 of 2019 stands dismissed on default. LCR is to be returned. So,
8/8/2023. Then?
the present appellant, being a private company, has a lot of process to be followed. The present appellant has 2 branch office, one in Jorhat and one in Akardala, has a regional office in Gauhati, and also a zonal office in Kolkata, and head office in Chennai. So they have to follow lots of process in dealing with the files. The branch office has to send it to regional office, then the regional office has to transfer it to the zonal office, then thereafter from the zonal office to head office. They have lots of procedures to be followed. So, yes, the earlier advocate...
Notice was received.
Yes, the earlier advocate who was appearing in the case has withdrawn from the case, and notice was sent through the court. That was received, yes. But while the paper was in process, the file was in process, and the appeal got dismissed on default on that day. And that's how I have explained the delay, how delay was caused, starting from my para 6, which is at page 4.
Yes.
I may be allowed to read. Para 6, that your humble applicant begs to state that as a private sector general insurance company limited is required to act strictly as per the laid-down procedures, and as such, the files are required to be routed from one office to another, and only thereafter the final decision to prefer an appeal or necessary application or not is taken after obtaining the opinion of the dealing advocate as well as the advocate practicing in the High Court, and in the procedural aspect, considerable time is spent. 7, that the applicant submits that though the impugned order was passed on such and such 8/8/2023, the same was not made known to the appellant as the earlier counsel had withdrawn the Vakalatnama without prior notice to the appellant. The appellant was not aware of the notice sent by the registry of this court. As such, after a lapse of some time only, it was made known that the appeal has already been dismissed on default. Immediately thereafter, the appellant directed the empaneled advocate to get a certified copy of the order dated such and such, which was received by the branch office at Jorhat only on 4/12/2023. Till such time, the appellant had no knowledge of the order being passed against it, and the same was sent and received by the Gauhati regional office on 15/12/2023. The concerned legal manager was on official door at Nagaland from 14/12/2023 to 31/12/2023. Only after his return, the impugned order was intimated to the zonal office at Kolkata from the Gauhati regional branch on 5/1/2024. That the Zonal Office Kolkata transmitted the case file to the Zonal Office on such 8/1/2024, and the same was received on 11/1/2024, which was in turn intimated to the head office at Chennai on 15/11/2024. Even after receiving this same mail was sent to the engaged panel advocate at Kohima on 20/1/2024. The panel advocate received the required instruction. However, the same could not be acted upon as she was compelled to halt her preparation as she was on her maternity leave till 26/2024. Thereafter, again, she got injured and was physically disposed till 25/10/2024. That the panel advocate, even though she recovered from her injuries, was not in a position to study and draft the necessary application as requested. Therefore, she requested Ms. Such and Such to draft and file the same on 27/10/2024. However, when inquired about the status after revocation of the court, Ms. Such and Such expressed her inability to file the same on 21/1/2025. That thereafter, the panel advocate requested Mr. Such and Such to file the same on such in 23/1/2025 through phone call. However, Mr. Such and Such was out of station and decided to meet after his return. On his return from journey on 2/2/2025, informed the panel advocate that the panel advocate met the present advocate on 6/2/2025 and handed over the file. However, the present advocate went out of station for medical purpose and returned only on 28/2/2025. Thereafter, the present advocate studied and drafted the present application and could file the same only on 26/3/2025. That counting from the date of the order till the filing of the present application, there is a delay of 564 days. So my humble prayer is that since the delay was caused out of all these reasons, it is my humble prayer that it may be condoned. The respondent.
Wait. When did the appellant office contact the panel lawyer for the first time?
21/2024, yes.
And certified copy was received on 8/8/2023. Okay. Yes. Any objection?
Lordship, the petitioner paid herein for condonation of delay of 564 days. Actually, there has been a delay of 597 days. In my para 4 of the objection, it is categorically stated there in Lordship. Para 4 of my objection, Lordship.
What is this? You have filed another application? Oh, regarding notice. Your objection.
Para 4, Lordship. Page 4.
Yes.
Minor, here, allow me to clarify this. This, out of these days, it has to be the limitation period to file the application, that is 30 days. So minus 30 days.
So this is my time. So allow me to submit.
No, actually, see, they don't have an office in Nagaland.
That is the main reason.
That is the main reason.
Lordship.
And technicalities, this court is not very strict on technicalities. I think we should go for the hearing on merits.
Yeah, Lordship, my objection may be, kindly allow me to
Of course.
submit before your Lordship.
Yes.
Here, Lordship, the petitioner paid only for 564 days delay. Factually, there has been a total delay of 597 days.
Okay.
97 days.
597.
97 days, Lordship. Out of which 564 days delay paid for condonation and 33 days is remain unexplained, Lordship. Lordship, in para 7 of my deposition in affidavit by suppressing the all material fact in regards to the information and notice received from the courts. The petitioner has filed a claim before this honorable court. Lordship, in para 7 of my deposition in affidavit, in para 7 of the petition, petitioner by suppressing the material fact alleged that lack of information and knowledge, the petitioner for restoration could not be filed in time is absolutely false, Lordship. The record of this honorable court clearly shows that the petitioner was put on notice well in advance regarding the withdrawal of their counsel, and despite repeated opportunities, the petitioner failed to take appropriate steps, which categorically proved by the following, Lordship. By email dated 12/4/23 and dated 16/5/23, along the accompanying letter clearly indicates that the then counsel of the petitioner has informed the company as well as the present petitioner, deponent, about withdrawal due to non-payment of fee, Lordship. True copies of the email dated 12/4/23 and accompanying letter dated 11/4/23 and 20/4/23, the email dated 16/5/23, also the accompanying letter dated 11/5/23 are filed herewith, Lordship. Lordship, apart from that, judicial order dated 10/4/23, 17/4/23, 2/5/23, 8/5/23, 6/5/23, 27/6/23, and finally 8/8/23 collectively demonstrate repeated and adequate opportunities afforded to the petitioner, Lordship. Lordship, para 10 of my affidavit in page number 7, Lordship. The petitioner sleep over the whole year, whole times. The petitioner was jolted into action only upon receipt of so-called notice dated 22/1/25 issued by the member Motor Accident Claims Tribunal Kohima in execution case number 4 of 24. The fact which is material and central to the timeline of the event has been deliberately suppressed by the petitioner in the present petition, thereby discrediting the bona fides of the present plea. Lordship, all the facts has been suppressed in this petition, though even from the honorable court, even from their counsel, earlier counsel has given sufficient notice and information. Despite the fact they have not taken steps to proceed with the matter, Lordship. Otherwise also, Lordship, the petition filed for restoration of appeal actually not maintainable in the eye of law. Restoration cannot be, Lordship. Under what provision they have filed a restoration petition is not known. Actually, petition should be filed under Order 41, Rule 19 CPC for readmission of appeal. Here they have filed for restoration of petition.
It was dismissed for default, isn't it?
It is dismissed for default. Even it is dismissed for default, then only Order 41 CPC. Order 41, Rule 19 of CPC is applicable only for readmission of appeal, not for restoration, Lordship.
So this annexures F to L are the various orders passed by the court, isn't it?
Yes, Lordship. Various order passed informing the petitioner. Even their counsel also issued so many email along with the court orders, but no response. Now they will come with a plea that they have not been informed at all. And after receiving information from this honorable court, while they were trying, meanwhile the matter was dismissed for default, Lordship. That is not correct, Lordship. Here, Lordship, in para 5 of my objection, the allegation regarding ignorance of the dismissal order dated 8/8/23 is false and contradicted by the record. The petitioner in para 4 of the petition admitted that notice regarding withdrawal of Bhokalotnama was received from the registry, and before any action taken by order dated 8/8/23, their appeal dismissed by the court. The petitioner herein purposely suppressed the material fact about the date when the notice was received from this honorable court, which is crucial in the computation of the delay. Nowhere mentioned that when they have received the court order, which is essential for computation of the delay. Everything is suppressed in this petition. Under these circumstances, the delay cannot be condoned, Lordship. Even there is a full bench decision of the Honorable Supreme Court. AIR 1960, Supreme Court, page 260. Para 19, Lordship. Wherein Honorable Supreme Court held that.
Where is that? Are you supplying the? Anyway, okay.
Yes, Lordship.
You give the citations later.
May I forward this copy? Wherein Honorable Supreme Court held that while paying for condonation, the entire period of delay must be explained. Not partially, Lordship. This is the findings of the Honorable Supreme Court. Your Lordship was also the whatever ground set forth in the petition, it is appeared that the grounds, the cause of delay, because of their official management and the movement of file from one table to another, which cannot be a good ground for condonation of delay, Lordship. I'd like to refer your Lordship's order.
See, before the petition was dismissed for default,
yes, Lordship.
Just look at all the orders. The behavior of the applicant is not very satisfactory. So many orders. Have you seen?
Yes,
Enclosed
Lord.
in their objection. Yes.
Lordship, by order dated 23/6/25, passed in ICICI Lombard General Insurance and Rumi Soikia, wherein your Lordship was pleased to held that movement of file from one table to another cannot be a good ground, on the basis of which no delay can be condoned.
The Postmaster General case is.
Yes, Lordship. Yes, Lordship. If the petitioner come with a clean hand, that is different issue, Lordship. The petitioner herein suppressed the entire fact. This is my submission before your Lordship. Petitioner is utterly failed to explain reasonably for what reason they were suppressed and not to able to file the petition in time. Otherwise also, petition filed for restoration of appeal is not maintainable. If at all petition to be filed, that has to be filed under Order 41, Rule 19 of CPC, Lordship.
For readmission.
Yes, Lordship, for readmission of appeal only, not restoration, Lordship.
Yes. Not satisfactory. The delay explained by you is after it was dismissed in default. But before that, also see how it happened. Before that, so many dates.
My only humble prayer will be,
Yes.
my lord, since it was dismissed on default.
No, but before that, so many
the-
opportunities were given.
For
So
the
many.
ends of justice, it may be heard on merit. At least it may be heard on merit.
For condoning delay, merit of the case is not required to be considered by this honorable court. That is different.
When there is willful
Yes.
negligence, then how can this court allow this petition? The instant application under Section 5 of the Limitation Act, read with Section 173 of the Motor Vehicles Act 1988, has been filed by the applicant slash insurance company, praying for condonation of delay of 564 days in filing the restoration petition. Which one is the restoration petition?
I 36.
Restoration petition slash IA 36 of 2025, by which the MSC appeal number 2,
Yes,
number
ma'am.
2 of 2019 was dismissed in default. By an order dated 8/8, by an order of this court dated 8/8/2023. Stop. Para. Heard learned counsel for the applicant slash appellant, Mr. Takakichu. Also heard Mr. B.N. Sharma for the respondent claimant. Stop. Para. The main grounds taken by the applicant is that the impugned order dated 8/8/2023 was not known to the applicant, as the earlier counsel had withdrawn the vaklatnama without prior notice to the applicant slash appellant. Stop. The appellant slash applicant was not aware of the notice sent by the registry of this court, and as such, after a long lapse, it was made known to the applicant that the appeal had been dismissed on default. Stop. Immediately after the applicant came to know about the dismissal of the appeal, the impaneled advocate was advised to get a certified copy of the order dated 8/8/2023, which was received by the branch office at Gauhati only on 4/12/2023, and the same was sent and received by the Gauhati regional office on 15/12/2023. Stop. The concerned legal manager was on official tour at Nagaland from 14/12/2023 to 31/12/2023, and only after his return, the impugned order was intimated to the zonal office at Kolkata from the Gauhati regional branch on 5/1/2024. Stop. It is further stated that the zonal office Kolkata transmitted the case file to the zonal office. Zonal office where? The zonal office Kolkata transmitted the case file to the zonal office.
My lord, it should be head office to the
Gauhati.
head office.
Head office.
My lord, yes.
Zonal office Kolkata transmitted the case file to the head office on 8/1/2024, and the same was received on 11/1/2024. Stop. After receiving the same, an email was sent to the engaged panel advocate at Kohima on 20/1/2024. Stop. The panel advocate received the instructions. However, the same could not be acted upon immediately, as she was on maternity leave, no, as the impaneled advocate was, not impaneled, panel, as the panel advocate was on maternity leave till 2024. Stop. Thereafter, she got some injuries and was physically indisposed till 25/10/2024. Stop. Para. It is further stated by the learned counsel for the applicant that the panel advocate is recovered from her injuries, but she was not in a position to draft the necessary application, and therefore she requested, who is this Dondi? Therefore she requested
She's also an advocate.
Another panel advocate to draft and file the same on 27/10/2024. So, however, the other panel advocate expressed her inability to file the same on 21/1/2025. Stop. Para. Thereafter, the panel advocate requested the present counsel to file the same on 23/1/2025 through a phone call. But the present counsel was out of station and decided to file the same after returning from his journey on 2/2/2025. Stop. Thereafter, the panel advocate met the present advocate on 6/2/2025 and handed over the file, However, the present counsel also went out of station for medical purpose and returned only on 28/2/2025, and thereafter the present application could be filed only on 26/3/2025, thereby causing a delay of 564 days. Stop. The learned counsel submits that the delay of 564 days was not caused due to the negligence on the part of the applicant, but it was on account of circumstances beyond the control of the applicant, and therefore prays that the delay of 564 days may be condoned and the appeal may be restored, and the restoration application may be taken up for consideration by this court. Stop. The learned counsel, Mr. B. N. Sharma, appearing for the claimant respondent, has filed his objections and submits that the actual delay is 597 days and not 564 and not 564 days, and that 33 days of delay has been unaccounted for. So, the learned counsel further submits that the previous orders passed by this court in the MSc Appeal 2 of 2019 has been suppressed by the applicant, and all the correspondence by the correspondence from the panel advocate,
Yes, Lord
these
Chief.
emails
Yes,
from
Lord
the
Chief.
panel advocate to the applicant company has also not been shown, has also not been enclosed by the applicant in the petition. So, it is also submitted that the present application is also not maintainable in as much as the application could have only been filed for readmission of the appeal under Order 41, Rule 19 of the CPC. Stop. The learned counsel for the respondent/claimant has drawn the attention of this court to the various orders various orders passed by this court in MSc Appeal 2 of 2019, which are enclosed as annexures F to
K.
F to L in the objection filed by the claimant respondent. Stop. In view of the above, the learned counsel submits that the applicant has not been able to show any sufficient cause for the delay caused in filing the restoration petition, and that the applicant slash appellant has not been pursuing the appeal with sincerity, and therefore prays that the present application may be dismissed. So, para. The court has considered the submission of the learned counsels and has also gone through the pleadings as well as the annexures enclosed therein. Stop. A perusal of the orders passed by this court in MSC 2 of 2019 has also been observed, has also been seen, has also been noted. Stop. In the order dated 10/4/2023, 17/4/2023, 2/5/2023, 8/5/2023, 5/6/2023, 27/6/2023, and finally 8/8/2023, it is seen that the appellants had been given ample opportunity by this court. Stop. The court had also allowed the panel advocate who was engaged earlier to seek instructions as to whether the applicant slash appellant would like to pursue the appeal further. So, the learned counsel for the appellant slash applicants had also brought to the notice of this court all the correspondence made to the appellant company, showing that no response had been forthcoming from the applicant slash appellant. Due to the non-cooperation, he had withdrawn, isn't it, the first counsel?
Yes, Lordship. Yes, Lordship.
Due to the non-cooperation by the appellant slash applicant, the previous counsel who was appearing for the applicants had also withdrawn his vakalatnama.
Thereafter, the registry of this court also sent a notice by annexing the order of this honorable court.
Thereafter, the registry of this court sent a notice to the applicant slash appellant enclosing the order of this court. Stop. However, none appeared for the applicant slash appellants even after the notice was sent. By order dated 27/6/2023, this court had also observed that the notice sent by the registry had been delivered to the applicants on 8/5/2023. In spite of receiving the notice and in spite of the opportunities given to the applicant, this court on 8/8/2023 observed that the applicants slash appellants the appellants failed to be present in the court in spite of several opportunities, and therefore the appeal was dismissed on default for non-prosecution on 8/8/2023. A perusal of the several orders passed by this court goes to show that the applicant slash appellant has not been diligent in pursuing the appeal, and the behavior of the applicant appellant shows that there was willful negligence on the part of the applicants in pursuing the appeal. So, even in the present application filed for condonation of delay, this court has seen that no sufficient cause has been shown except for routing of files from one office to another. In view of the above, the present application is dismissed.
Much obliged.
And in IA 36 also, we say in view of the order passed in IA such and such, the present application is also dismissed.
Obliged.
Item number 13 and 14.
May I please, Your Lordship, here the state respondent is yet to file affidavit, Lordship. If Lordship may please to list the matter after 3 weeks, Lordship. In the meantime, we'll be filing our objection.
And what about informant? Notice on
Yes, Lordship.
respondent to
We have served.
served.
Yes, Lordship.
Dusty.
Yes, Lordship.
Okay, learned counsel for the petitioner, Mr. Such and such present. Steps on respondent number 2 has been taken by the petitioner by Dusty Service and the compliance affidavit.
We have also give copy to the court also, Lordship. The affidavit of service.
Yes,
Lordship.
yes, and the compliance affidavit has already been filed on 25/11/2025. So, did we pass any order for deemed service?
No,
Okay,
no.
okay, 8/12, it's already done. Okay, by order dated 8/12/2025, this court has already observed that the notice upon respondent number 2 is deemed served. The learned public prosecutor, Mr. V. Momi, submits that he would like to file an objection affidavit and therefore prays for how much?
3 weeks time.
3 weeks time. So, bring me list after 3 weeks.
Much like.
Item number 15.
No, there is an additional affidavit which has been filed by us before this court.
Additional affidavit, okay.
Lordship got it? Your Lordship goes additional affidavit, just 3 minutes, I'll just explain. What was the case about? It was a criminal petition which was filed against an FIR which was lodged by one of the informant. Now the contents of the 2010, your Lordship will kindly note down the incident is of 2010. Now, this will be narrated in the order sheet of this court, Honorable Court, while protecting me in this case. One informant case in the FIR is that one late Arun Batoria has taken a sum of rupees 5 crores in cash in 2010 and in his personal capacity. I'll show it. And he said 30% of the profit will be given to him or returned. And now this petitioner has been dragged in this case. He has no connection. It is in a personal capacity the loan was taken by one late Arun Batoria. Now he is saying that this money was parted somewhere, not in the receipt. His contention in the FIR is that in presence of the director of one company known Epcon. And this person who has taken, he was not even a director of the company, he resigned earlier. In his personal capacity that 5 crores was taken. I can't understand a 5 crores, my lord, in cash 1 crore paid in Dimapur and 4 crores was paid in Calcutta. That's their case, what they projected. Now, when I move this matter before this court, kindly see the affidavit, the order that is at page 15, kindly see, my lord. The additional affidavit, 15.
Additional affidavit.
Yes, please see at page 15. Order of 10-12, Lordship got it?
Yes.
Please turn to page 16 and see paragraph 3, my lord.
Yes.
It is submitted by so-and-so, learned senior account, the case of the present petition was initiated on a transaction of money in the year 2010 with one Arun Botoria, who died in 2011, wherein there was a transaction of 5 crores, and as per statement made in FIR, all these transactions were in cash. And the present informant was assured that he would be paid 30% of profit for the said amount given. The transactions were purely commercial and not a case of simple entrustment of property or money. Rather, it is a commercial transaction where it was promised to pay 30% of profit to the present complaint. But from the money receipt which was given a letterpad of the complaint, it reveals that the entire transaction was taken place in presence of one Pradeep Agarwal. And in the said letterpad, there is no mention at all about the presence of the petitioner, who is stated to be one of the directors of the company, namely FCON. But the same Arun Batoria was not a director of the said company at the time of transaction of money, and what has been done was purely a personal transaction. The petitioner was not even present at the time of transaction, but only for procuring money. The name of the present petitioner along with the 2 directors' name has been mentioned in the FIR. The entire transaction was completed in the year 2010, but after a gap of long 15 years, the present FIR has been lodged in the year 2025. Learned so-and-so submitted in the year 2023. After 13 years, a GD entry was made, but it was kept in abeyance, and some assurance was given from the accused person, and subsequently FIR is registered only in the year 2025. The learned senior counsel submit that these are all oral submission from the informant, but there is no documentary evidence except the money receipt of substantiate the plea of the complainant that a transaction was completed in the presence of petitioner, who is one of the directors of the company, namely FCON. Further, it is submitted that as per one notice under section 35(3) BNSS was stated to be issued on 14/10, directing the present petitioner to appear before the IO on 31/10/2025, but the present petitioner never received a notice under section 35(3) BNSS, as he is presently in the US after the miscarriage of his daughter, and since August 2025 he is in the US, but without even receiving the notice, and order of issuance of NBW was procured by the IO, and subsequently by order dated 2/12/2025, learned magistrate has withdrawn the NBWA, which was issued earlier against the present petition. Further, citing judgment of the Honorable Supreme Court in so and so, it is submitted there is no ingredient to attract neither section 406 nor 409 as registered against the present petitioner, and the law clearly recognizes the difference between simple payment, investment of money, and entrustment of money or property. But here in the instant case, as it is seen from FIR itself that it was purely a commercial transaction, wherein the informant was assured to be given 30% profit by late Arun Batoria. Thus, there cannot be any case against the present petitioner under section 406/409 IPC. However, it is submitted, present petitioner is ready to cooperate with the IO in compliance with section 35(3) BNS, and he may be interrogated virtually as he is presently staying in US. Further submitted that no coercive action may be taken against so-and-so, ready to extend his cooperation. The learned PP Nagaland has submitted cases still under investigation, and his presence, kindly see my lord, please note down, and his presence is required, for which notice under section 35(3) BNS has already been issued against the present petitioner, but despite of the notice, he is not cooperating with the IO, and hence his physical presence may be required for the interest of investigation. 8. Considering the entire submission made by learned counsel of both parties, perusing all the case record along with the annexures, the IO is hereby directed not to take any coercive action against the petition. However, the accused petitioner is hereby directed to extend his cooperation with the IO of this case. However, till the return from US, he may be interrogated or his statement be recorded by IO through virtual mode. However, the IO will also make enquiry in compliance with section 35(3) of BNSS after his physical presence before IO, preferably within the first week of February. So this was the order that was passed. Now, if your Lordship looks again at page 18 at paragraph 7, that the case is still under investigation and his presence required, for which notice under 35(3) NS has already been issued, right? And there is, if you see at page 19, at paragraph 9, it said once you return back, then your physical presence may be required. Now, thereafter, my lord, if your Lordship looks at page 20,
it says physical presence before the IO, preferably within the first week of February.
correct,
So
right.
has he
now,
appeared
now
physically?
what? Yes. Now he has appeared, everything done. See page 20, my lord. See page 20. There is an order after that also. See page 20. Kindly see on top, 16th of December 2025. Lordship got on the left hand side of the column, on the top email.
Yes, 16.
Now, if you see that we have written to the IO after the order that was passed by this court.
Okay.
We said, kindly see, Milan Shah, so and so, I hereby extend my full cooperation to the IO in terms of the order dated passed by Kohima bench. I respectfully request to record my statement through virtual mode, as the Honorable Court has permitted that till my return from US, I may be interrogated or my statement be recorded virtually. I have given this address. Kindly see the address. Now, what has happened thereafter? If you see at page 21, instead of recording my statement, they have sent a notice under 34. Lordship got it?
Yes,
94 and 35(3) of BNSS. Kindly see, my lord. Right? And 3 of the companies, kindly see, one is to the director Janit Nirman, which has nothing to do with this present company which they have brought in the FIR, is FCON. They are saying FD FCON. I am not the director now also, my lord. They are saying about Janit Nirman. If your Lordship turn to page 28, that is Drishti Towers at page 22. Drishti Tower and 23, please turn to page 23. Adbhut Vinamay, private. My lord, no problem. I told my client that whatever you have to cooperate. 34 you have to. Now, according to what has happened thereafter, please see, interesting. Now, at page 20, we have given a reply. All of them we have given reply. I'll show. All reply has been complied. See page 26, my lord. At page 26.
Yes,
See page 26. If you see on the top left hand side is 9th of January 2026. Now 16th of December 2025, while I wrote that please record my statement to virtual. They have not done. So 9th of January, again I made a reminder on 9th of, kindly see, my lord, to follow up my earlier request through so and so and record my statement virtual mode in terms of the order of 10/12/2025. And my address again I have given. Right, and these are, my lord, earlier email of 16th of December. Now, reply to the notice at page 28. 3, my lord, those notice 94 at page 28. Page 28, I replied. Kindly see subject, reply to notice under section 94, 35(3) BNSS. I replied. And also I sent it by post. From page 28 is the one company. All the annexures, see place 29, see below 29, all the annexures I have, what they have sought I have given. Now see page 30, my lord. It is also by post. It has been sent to them. 14/1/2026.
So you are the director of this Zenit Neriman?
Yes, it nothing to do with those APCON, which they have now, they want, I have given, my lord, I have to comply. 30, my lord, it is by post also we have sent. 32, along with all the annexures. 32 is also one of the complaint district hours. It has been sent. Now all this has been sent up to 30. My lord will kindly to up to page 41. Right, my lord, up to 41. All complied. See now, till then my statement was recorded. What has been done? My statement is recorded. We came at an IA. See at page 42, my lord. We came in IA 42. My statement not recorded. They are asking about 94. See 19/1/2026. IA has been filed. Now, if your lordship now turn to page 43. See 43, my lord. Mr. Das so and so submit the applicant has communicated by email requesting his statement recorded to virtual mode is directed by order dated 10/12 so and so. However, no reply was received from police authorities. The applicant again on 19/1/91 sent a follow-up email requesting the same. Till date of filing of the incident, no response has been received from police authorities. By filing this interrogatory application, applicant seeks direction of the compliance with the order dated 10/12/2025 passed by this court in so and so and or dispensation of the notice under so and so. Applicant also prays for modification of para 9 of the said order to the extent statement may be recorded first by virtual mode till then his physical presence before the I was directed by this court be kept in abeyance. So and so provide applicant. Now they wanted my contact number. Now please turn to page 44, my lord. And this in addition to the earlier contact details already provided. So and so email the learner has provided alternative number of the applicant. I have given an alternative number because I was abroad. In view submission, the applicant accordingly, IO self first record this statement through virtual. Till then, the physical appearance of the applicant before IO as directed earlier by this court in paragraph shall be kept in abeyance. Right, my lord? Now, if you turn to page 45,
so now physical
now my
appearance
statement,
kept in
now,
abeyance.
yes, now my statement has been recorded. If your lordship kindly see page 45. See page 45. Your lordship can note down my statement recorded virtual on 28/1/2026. 28/1/2026.
Statement recorded.
Yes, recorded. As per direction of this court.
Through VC.
Correct, my lord. Now see the order of 29/1/2026. Now if your lordship turn to page 46, now 3:2 at page 46, the learners so and so submit that the applicant in terms of the court's order dated 10/12 and has fully cooperated with the IO and his statement has been recorded through WhatsApp. His physical presence for IO is not possible because he is still in USA in connection with miscarriage of the daughter since August 2025. Learner senior counsel submitted since the appellant has fully cooperated with the IO wherein he was not involved in the commission of any offence, prayed that the instant IO may be allowed, the IA may be allowed by dispensing the necessary of him physically present for recording his statement before the IO. Now, number 3, learned PP submits that the statement of the applicant recorded through virtual mode, WhatsApp, and has produced a document showing the status report dated 28/1/2020. He submits perusal of the status report shows applicant in the statement has denied his involvement in connection so and so. Learned public further submit since the statement of the applicant has been recorded, the physical presence of applicant before the case IO may not be necessary at this stage. Your lordship got it? Now see, on considered submission made by learned counsel of both party, statement of the applicant in terms of the court's order dated 10/12/2025, 19/1/2025-26 has been recorded by the case IO as per the status report dated 28/1/2026, which is being made a part of file and mark X. In view of the above, this court finds it appropriate to allow the IA by dispensing with the necessity of applicant physically present for recording a statement or the issuance notice under 35(3) of so and so stands allowed and disposed of. Now this my physical appearance dispense my statement. Now my lord, I have 94 complied. Again, what they have done 48, kindly see. 48, my lord. Page 48, again fresh notice. Fresh notice under 94.
No.
Again, same.
Page
Earlier,
48.
48.
Page 48 is a rejoinder.
No.
Rejoinder and fresh questionnaire.
Yes,
Okay.
you are correct,
Questionnaire
right.
Under section 9.
Kindly see, my lord, what I told, even then you comply. Same, repetition of same. I said, but when 94, you have to comply. All it is complied. Page 48 of 3 companies, again, my lord, 3 companies, 48. Now kindly see, 50, same, my lord, where same company. Now kindly see, if you see at page 50, it's like mechanically see page 50, 1, kindly see 1, certified copy of so and so, it is SO of Zenith Nirmal, it is district tower. Just mechanically photostat, my lord, whatever may be, my lord, photocopy, and but is a district, it has been addressed, but they want some certified copy of incorporated Zenith. Right, my lord, now see 52, my lord, same, it is again Adbhut, same.
So again, some documents have been.
I supplied. I sought for some extension of time. See at page 54, my lord. It's a huge, my lord, I crave leave of this honorable court. It is a huge bundle I have sent to them. My lord, see 54. Email seeking extension of 3 weeks time. It's not possible. So huge. Even then, my lord, 3 weeks time I sought. Kindly see last. Request I grant an extension of 3 weeks time on date of receipt. Prescription so and so, including where appropriate, so and so. Now, 59, see page 59. 59, these are all 3 companies I prayed. At page 59, now they reject and they say only 7 days time is granted to you. Absolutely no problem. I told the client, whatever you want to do, do it. Send it to them. So, at page 66, I complied by email and post at page 66. Up to page 68. Up to N, sorry my lord, up to N. I send up to N. Everything I have done it. And 68 is the letter which has been sent by post. Same letter which has been sent by post. And kindly see 68, all annexure A, B, C, D, everything has been sent to them. They cannot have any regret in not sending it notice. What I am now before this court, what I am projected. Once I have been, my lord, there is prima facie your lordship has said. Of course, your lordship has decided this case and time away. What I am saying, this is an old man, my lord. Let him not be harassed. So what I am saying, my lord, at least so far as now, so far investigation concerned, quota petitioner, they should not proceed, my lord. It is under the hands of this court. Your lordship will decide. Why all the time, my lord, kindly see in what manner I came to the court. And see prima facie what case, my lord. If your lordship looks, I don't want to trouble this court. See on what basis they want to proceed. At page 54, kindly see the main petition.
But after this last notice,
yes,
they have not sent anything. They have
no,
not said
that's
anything.
why I'm saying. My lord, I see why I have
Now
come.
you have supplied everything.
Correct.
Yes.
No, I apprehend that again they may ask something which is not relevant at all. My lord, 94 notice has to have a nexus with EPCONs. All this company, my lord, has no relevance. Even then, for the sake of the investigation, I have sent it. What I am saying at all today, my lord, before this court, so far as this quasi petitioner, all I completed, my lord, your lordship dispensed by this
No,
court.
but the first order issuing notice,
Yes.
this court has already said no coercive action.
No, absolutely no problem.
So
but
that still
they will,
remains.
No, there is no problem, my lord. No coercive measure is there. But toward the petitioner investigation, my lord, again they will come up with all this.
PP,
They will
now
make it.
IO has received all this, the latest.
In fact, I have not received the additional.
Oh. You have not
In the
served.
file copy, it is there, file copy. You have received, I think.
I have not. Huh? No, only the court's copy is there.
No, please see. Receiving, kindly see.
I'm for responding.
Yes.
That's what I'm saying, my lord. I'll move with all responsibility. My learned friend, I make it very clear, it has to be served. I absolutely no problem. My lord, if necessary, we'll serve it, my lord. That's no problem.
Lordship, I'm allowed some time to.
No, absolutely no problem. Let them take time. My lord, but they will not, my lord, ask for any notice now, my lord. This is too much,
Yes,
my
yes,
lord.
that is-
He's an old person, my lord. He's an old person. Any bereavement of his daughter has been, my lord, miscarriage.
Notice under section 94 and 35(3) BNSS again sent on 18/2. 18/2.
I'm allowed to take it.
No, I think now this is more than enough.
Yes,
Enough
right, that's-
information has been already provided to the IO. All the annexures are here. Yes,
And I bring annexure in this court, it is used bundle, already sent.
by email.
Yes, email, no, post also. Post, email, everything sent, my lord. What it means, this is going on, my lord. And this is an old person, bereavement shock office, even I told, please do come. And it has cooperated. So at least they will not carry investigation, quasi petitioner is concerned, my lord. Let them do whatever. We cooperated, everything, my lord. Your lordship will decide the issue. Let them not investigate quasi petitioner. I am all protected not to take coercive measure.
Okay, we'll fix a date for the final hearing, but.
Yes,
the date
yes.
was-
Lordship,
Yes.
I'm for respondent number 2, Lordship. I will be filing written objections, Your Lordship.
Okay,
So
you
3 weeks
file.
time will be given.
You file, yes. Learned Senior Counsel, Mr. D. Das, assisted by Mr. I. Das for the
And Mr.
petitioner.
Solo is there, ma'am.
And Mr. M. Solo. Assisted by Mr. I. Das and Mr. M. Solo, okay? Stop. Also heard Mr. B. Jamomi, Learned Public Prosecutor, and Ms. Esther for the respondent number 2. Stop. The petitioner has filed an additional affidavit on 6 March 2026 to bring to the notice of this court that another fresh notice under section 94 BNSS has been served on the petitioner by the investigating agency. Right, notice dated, the latest one dated.
Yes. 18/2.
18/2/2026. So, it is the submission of the learned counsel for the petitioner that by order dated 29/1/2026 in IA criminal number 2 of 2026, this court had already held that the petitioner that the physical presence of the petitioner is dispensed with, and further had also stated that the issuance of and has also stated that the statement of the petitioner/applicant has already been recorded on
28/1/2026.
Stop. However, subsequently, after the order dated 29/1/2026 was passed by this court in IA Criminal 2 of 2026, the investigating agency has again issued another fresh questionnaire under section 94 BNSS to the petitioner, seeking for further supply of further documents. Stop. Accordingly, the petitioner requested for extension of time to furnish the information, and the same was furnished by email dated
1/3/2026.
1/3/2026.
Page 60, 68.
Right, email dated 1/3/2026. So further, the petitioner also sent hard copy of the enclosures by post to the officer in charge of the suburban police station.
An email, hard copy.
By email as well as hard copy. No?
I'm sorry to interfere at this
Yes.
moment. My lord, prior to this, 14/1 also they sent a same. 14. 3/1.
First was
3/1/2026.
2026.
That also notice.
Then after that 18/2.
Yes.
Is it?
Yes, this is what. All same.
So you just say first one was 3/1/2026, okay? Instead of 18/2, you say 3/1/2026. And thereafter replies were sent. Nah. Then after that again, you say next para. Thereafter, the investigating agency again sent the same notice under section 94 and 35(3) BNSS to the petitioner dated 18/2/2026. Seeking for further documents from the petitioner. Stop. Subsequently, the petitioner by letters, by emails dated 2nd March 2025.
One is 1/3/2026 at page 68.
No, this is the letter, this is the hard copy.
Yes.
And then the email you had sent on 2nd March, isn't it?
No, first is 1/3. One annexure we missed, so we send it on 2nd.
Okay.
One we missed on.
Therefore, thereafter, the petitioner has sent all the required documents
1st and 2nd March.
by letters dated 1/3/2026 and 2/3/2026. Stop. It is the submission of the learned senior counsel for the petitioner that the petitioner has been cooperating with the investigation all along and has been supplying and has even recorded his statement and has been supplying all the documents required by the investigating agency. However, the petitioner has been subjected to harassment by the investigation agency in as much as the same notices under section 94 CRP BNSS has been sent to the petitioner time and again by the investigating agency.
Sorry for the interruption.
Yes.
Since the criminal petition has been referred by the petitioner, Lordship, whether additional affidavit order can be passed on the additional affidavit, Lordship?
No, this, we are passing this in the main case only.
Yes.
Not in the additional affidavit. This is just bringing to the notice of the court.
Yes, correct.
Therefore, by bringing these notices to the attention of this court, the petitioner prays that during the pendency of this present criminal petition, no further notices may be sent to the petitioner under section 94 and 35(3) of the BNSS. This court has considered the interim prayer. This is an interim prayer only.
No, that earlier prayer that will continue also, madam. No coercive measure.
No, that is already there.
Yes.
It's okay.
No investigation,
the interim prayer of
no
the
further
petitioner,
investigation.
And it's therefore directed that till the next date of listing, no further notices may be sent to the petitioner in connection with the instant case. Okay. List when?
Earlier order will continue, that also.
And the earlier interim orders passed shall also continue till the next date. The learned counsel for the respondent number 2 prays that she may be given 3 weeks' time to file an objection, and you also file, and the public prosecutor also makes a similar prayer. Accordingly, list after 3 weeks. List after 3 weeks. You want a fixed date?
Yes, on 38 is okay. 38 of March is Monday.
Learned senior counsel
30.
prays that the matter may be fixed on
38,
30
March.
That will be 3 weeks.
It's
No, that is
20 days.
That is too short, I think, because today is 10th. Yes.
Then, so it can be
First week of April.
first week of April. will
First,
be
second, 6th.
6th to
No, 6th. We have already fixed that other matter. No, 7th.
7th.
7th. Fixed on 7th April 2026. Yes. And you make sure that you serve a copy in case he has not received the additional affidavit.
I'm deeply obliged, madam.
For orders, item number 16.
May I please, Lordship? My Lord, here I have instruction to appear on behalf of respondent number 4. So can you allow me 3 weeks' time to file, to obtain instruction, and meantime I may allow to file.
Respondent 4.
Wakalan number, yes, my Lord.
Learned counsel for the applicant, Ms.
Lordship, I'm for respondent number 2.
Such is present. Learned counsel, Mr. Tiba Pom submits that he has received instructions to appear for respondent number 4.
4, yes.
And prays for
3 weeks' time.
3 weeks' time to receive instructions. So, prayer is allowed.
And for respondent number 2.
Such and such appears for respondent number 2. Are
Lordship?
you also filing? Yes.
Yes, I have already filed the affidavit.
Filed, okay.
Yes.
For
Lordship,
respondent-
here in the cost list, my senior's name, N. Longomer, is not being reflected, so if you may kindly direct the registry to reflect the name of my senior.
Okay. List after 3 weeks. The registry is directed to show the name of Mr. N. Longcomer as counsel for respondent number 2 in the cost list. Yes.
Much obliged.
Much obliged.
Item number 17.
May I please, Your Lordship? Your Lordship, I may be allowed to place some submissions, Your Lordship, in respect to the instant petition, Your Lordship. Your Lordship, while filing the instant petitions, because of my negligence, Your Lordship, I have left out the section 1154, which is a revision of Your Lordship, inadvertently. So, if my Lordship would allow me to modify my petition, Your Lordship.
No, but already 9/3/26 office note says that you have filed an amended cost title.
Your Lordship, it is in respect of the deletions of the respondents, Your Lordship.
That was in respect of the parties.
Oh, okay,
Respondent 3 and 4 were deleted.
Okay. So now you want to file an amended petition?
Yes, Your Lordship. Yes, Your Lordship. In respect to the addition of the section, Your Lordship, on 1
Where do you want to amend?
in the cost
title
title.
itself?
Yes, Your Lordship. In the cost title.
Okay, okay. Or you file an IA then, in that case?
Your Lordship.
Learned counsel for the petitioner
Your Lordship,
submits that
I'm
yes.
appearing for respondent number 1. We have received instruction to appear on behalf of respondent number 1. Kindly allow 4 weeks to file wakalat nama and affidavit.
Okay, but he also has to file the IA first, so just wait. Learned counsel for the petitioner, Mr.
Chin Yang Pom.
submits that he would like to file an IA for amendment of the cost title. As due to inadvertence, some mistakes have been made. Stop. The prayer is allowed. The petitioner shall file an IA within 1 week. Within a week from
Yes,
today.
Your Lordship.
Stop.
Within this week, Your Lordship.
Within a week from today. Stop. In the meantime, Miss such and such, your name? Miss such and such submits that she has received
Renmoni.
instructions to appear for respondent number 1 and prays for 4 weeks' time to file wakalat nama and the objections. This is civil revision and the affidavit in opposition. Stop. Learned counsel, Mr. I. Jamir appears for R2. Stop. Are you also filing any
We
affidavit?
yet to file our counter.
Okay. He also prays for some time to file the counter affidavit. Stop. List after 4 weeks.
Your Lordship, there is an interim.
The interim order passed earlier shall continue till the next date. And then you file your IA?
Yes, Your Lordship. Obliged, Your Lord.
Item number 22.
Yes.
May it please Your Lordship. Your Lordship, as per the last order, Your Lordship, 2702 to 26, Your Lordship. Notice have been completed upon all the respondents, Your Lordship. If notice be deemed complete, Your Lordship.
The status of case.
I'm for respondent number 6. And
So all the respondents are represented?
Your Lordship,
No.
for 2 and 3 and 6, Your Lordship, they are represented, Your Lordship. For the other respondents who have served justice service, Your Lordship, to which they have accepted and received the copy as well, and to which we have already served our affidavit of notice, Your Lordship. Lordship,
And,
however,
and
they-
you have filed affidavit?
Yes, Your Lordship.
When? 5th December. This one?
25th December, Your Lordship. 25th, 11, 2025, Your Lordship.
Learned Counsel, Mr. M. Solo, who is present for the petitioner, is submitted that the first steps for notice has been taken by Dusty on respondent number 1, 2, 4, and 5. Is it?
Yes, Your
1,
Lordship.
2, 4, and 5. And the compliance affidavit has also been filed on 25/11/2025. So today, when the matter is called, Mr. V. Zimomi appears for the
Respondent number
number 6. Stop. Miss S. Chang appears for respondent number 3. Vaklat number has been filed or not?
No, Lordship.
It's there. It's
Lordship,
there.
I have filed for respondents.
S. Chang appeared for respondent number 3. Stop. Upon going through the records, it appears that the Vaklatnama has also been filed on behalf of respondent number 3 and 6. Stop. However, none appears for the respondent number 1, 2, 4, and 5 when the matter is called.
Lordship, the
As compliance affidavit has already been
Yes, Your
filed,
Lordship.
it is, the notices on respondent number 1, 2, 4, and 5 is deemed served. You inform them, because if they don't appear after service, then the implications will not be very good.
Lordship.
Okay.
Your Lordship, this matter was disposed on the 26th of 6, 2025, Your Lordship, where direction was given to consider the matter of the petitioner before his retirement, that is on July, Your Lordship.
For regularization?
For regularization, Your Lordship. Now, Your Lordship,
get
I've
the
already been
instruction.
retired. I'll get the instruction and we'll be filing our.
No, even if you retire,
Yes,
if
Your
they comply, then you'll get all
Lordship,
the
yes, Your
benefits.
Lordship. Your Lordship, main issue is I'm 61 years old now, Your Lordship. Lordship, I'm not in good health, Your Lordship. If short time be given, Your Lordship, to the respondents.
The respondents, the counsel for the respondent, Mr. V. Zimomi, prays for how much time?
3 weeks time.
3 weeks time.
Lordship,
to
if 2 weeks time be
receive
given, Your
instruction. It's okay, let them get 3 weeks to receive further instructions regarding the compliance of the order of this court.
Lordship.
So, list after 3 weeks.
Much obliged.
Item number 25.
Learned counsel for the petitioner, Ms. Sarjan is present. The service report in respect of respondent number 1, 2, and 3 is still awaited as per the office note dated 12/1/2026. Would you like to take first steps? Because, okay, list after 3 weeks, awaiting service report on respondent 1, 2, and 3.
Item number 26.
Lordship, in this matter, the service report for respondent number 6 and 7 is still awaited, Your Lordship.
Learned Counsel, Ms. Kim Penny is present for the appellant, and Mr. Nedovero appears for the respondent number
1 to 5.
1 to 5. Stop. The service report on respondent number 6 and 7 is still awaited. So please, after 3 weeks, awaiting service report on respondent number 6 and 7.
Masuk pula, Your Lordship.
Item number 27.
May it please your Lordship. Lordship, I have instruction to appear on behalf of respondent number 1. Lordship, 3 weeks time may be given to file my Vagalanama, also objection in the IL, Lordship.
2 and 3 also. Service
still
report.
awaited, yes, Your Lordship.
Learned Counsel for the appellant, Ms. Kim Penyo is present. Stop. Mr. Imti Wapam enters appearance on behalf of respondent number 1 and prays for 3 weeks' time to receive instructions and to file the Vaklatnama.
Lordship.
The service report on respondent number 2 and 3 is still awaited. So this after 3 weeks.
Highly obliged, Lordship.
Item number 28.
Lordship, the leading counsel, the lead applicant counsel is on bereavement and he wants to list the matter on Thursday.
Okay. Learned Public Prosecutor, Mr. Lee Jimumi is present. The counsel for the petitioner, Mr. Pokim Yadan, is in bereavement. List on Thursday, 12. List on 12/3. You have the
Lordship,
case
I
diary?
have- Yes, yes, Lord.
Item number 30.
I think 30 is already mentioned. I think. Wait.
For hearing, item number 31 and 32.
Yes.
Yes, may it please, Lord. My Lord, my respectful submission is that in the impugned order, there are no infirmities on impugned judgment degree dated 31/03/2014. There are no infirmities. The trial court has marshaled the evidences on record and rendered the reasoned judgment order as per law. Your Lordship, as per the argument advanced by my earlier senior counsel, I'll confine to the point raised by the said counsel. My Lord, it may be relevant to see the cause title of the suit, which is at page 26.
Page 26 of the paper book? Or
Yes, paper book. My Lord, after the name of the parties, here the suit for declaration of a mortgage deed dated 13/05/06 as void and illegal, reopening and readjustment of accounts, disentitlement to future claims and perpetual injunction, etc. My Lord, here the annexures which has been annexed by the plaintiffs, that is from page 39 to 45. Page 39 is the Jamawandi copy of the said land.
Page 40 is the affidavit of the plaintiff number 1. Then page 17, that is the receipt of rupees 12 lakhs issued by the PW number 3 and PW 9. Then the pertinent annexure is at page 43, that is the mortgage, deed of mortgage. My lord, here the contents of the mortgage is, that is, may I read, your lordship? Mortgage deed. I, Sri C. Among Jamil, son of Sri S. C. Jamil, residents of Hafnagardan, Dimapur, Nagaland, do hereby mortgage by land covered by Pata number so and so, Dag number so and so, Moja number Dimapur town, measuring so and so, with all buildings and fixtures therein, hereafter referred to as the said premises, at the consideration of rupees 70 lakh on the mortgage period, and the mortgage on the mortgage period is effective from 13 May 2006 to 14 January 2007, failing which I shall forfeit my said land to him. I agree to pay the interest every 2 months. I hereby deliver the original Jamabandi title deeds of the said land to him. That the said land is free from all encumbrances such as litigations, attachment from decree and or any other claims. And I sign this deed in the presence of the following witnesses. This is the 13th May 2006 at Dimapur. Your Lordship, now the counsel of the appellate, he has argued saying that this deed was executed on 13th May 2006, which was later on rectified on 3/11/2006. The earlier that 13 May 2006, on that day 50 lakhs were transacted, and on 3/11/2006 another 20 lakhs were given, enhanced, so totally came to 70 lakhs.
13/5/2006, it was 50 lakhs.
50 lakhs.
Then 11/4.
3/11/06.
3/11/2006, another 20 lakhs.
20 lakhs, yes. So altogether, it stands at 70 lakhs. And the duration of the mortgage is for 8 months. And the interest payable is within every 2 months. And the title deed is given by your security. Your Lordship may kindly turn to page 27 of the paper book at para 7.
Page?
Page 28. Para 7. Thereafter, on account of financial constraint, the plaintiff number 1 was unable to pay the monthly interest for the next 2 months from 14/8/06 to 14/10/06, and to which the defendant on 3/11/06 calculated the defaulted interest for 3 months amounting to 12 lakhs rupees only, and compounded the same with the principal amount of rupees 50 lakhs only, and further by paying a cash amount of rupees 8 lakhs only to the plaintiff number 1, the defendant indiscriminately enhanced the principal loan amount to 70 lakhs only. Accordingly, with effect from 3/11/06, the plaintiff number 1 was asked to pay 6% monthly interest on the enhanced principal loan amount of rupees 70 lakhs. So earlier agreement, that is 13/05/2006, was 8% per month. But after the enhancement of 20 lakhs, the interest rate was reduced to 6%. Now, Your Lordship, the statement of plaintiff number 2, who transacted received the 20 lakhs, the subsequent enhancement, which is at page, my lord, at page
PW2.
Yes, in the page 56. Page 56. Your Lordship will find on the in the non-judicial paper the plaintiff number 2, Among. He has signed. This is date 3/11/06 on the left-hand side, also on the right-hand side. So this is after enhancement. Now, the other aspect is that he has clearly admitted at page 94. At page 94, Your Lordship. This is his statement in the cross-examination. On the seven para. Yes. It is correct that I received for the loan of rupees 20 lakhs on 3/11/06, and according to the mortgage deed dated 13/5/06 was amended by entering rupees 70 lakhs and interest at 6%, which I acknowledge and signed on the said mortgage deed on 3/11/06. Then at page 95, on the 12th paragraph.
1 minute. Yes,
Page 95.
95.
The 12th para. It is correct to say the loan amount of rupees 70 lakhs advanced by the defendant was used for the business purpose of the plaintiff number 1, who is my brother-in-law. Your Lordship, next paragraph also is important. I was aware of the risks undertaken by me by mortgaging my property for the loan secured for the benefit of the plaintiff number 1. Then at page 97, the second para. It is correct that the initial loan of rupees 50 lakh was obtained on 13/05/06, repayable within 14/1/07, and the subsequent 20 lakhs was also obtained on 3/11/06 for the said duration of 14/1/07. Then, Your Honor, the 10th paragraph. 10th paragraph. Same page, page 97. I deny the suggestion that the amount of rupees 20 lakhs received by me from the defendant as enhanced loan was utilized by me. Then thereafter at page 99. In the reclose, the first paragraph in the reclose, Exhibit D1 within bracket 3 is my signature, and I admit to the receipt of rupees 20 lakhs cash on 3/11/06 as written in Exhibit D1. So this is the admission of the plaintiff number 2. Now, because the 20 lakh was received by defendant, plaintiff number 2. Now, the statement of the plaintiff number 1, which is at page, Your Lordship, at page 81. At page 81.
para 8, cross-examination number 8, para 8. Before coming to para 8, my lord, at para 2, para 2, his statement is that I am a businessman by occupation. Then para 8. In regard to enhancement of loan to the extent of rupees 70 lakhs and making necessary correction in the mortgage deed is done by the plaintiff number 2 and I was not present. Then at page 82, para 9. It is correct to say, I do not know who received the enhanced amount of rupees 20 lakh. Next para also important. I admit that I was not present when the mortgage deed was corrected by enhancing the loan amount to rupees 20 lakhs. It is correct, next para, it is correct that the subsequent enhancement is written as 70 lakhs as corrected on 3/11/06. Then, Your Lordship, the last paragraph. The loan was availed in order to invest in my business project as well as to make base for assembly election. Then the PW number 1 at page 104. At page 104, para 4. The loan was secured for the purpose of investing.
What is it?
Actually, PW1.
Oh, okay. PW1.
Actually, there was some mistake in
Yes,
numbering the witnesses because actually the plaintiffs, they should be the PW1
Yes,
and 2. But
PW1
instead,
and 2. it should
yes,
be.
but instead,
But this one is also
Yes.
given as PW1. Page.
the loan was secured for the purpose of investing in electioneering purpose and for contract work of the plaintiff number 1. That is, the PW1 is the wife of the plaintiff number 1. Then 7 para. Para 7. It is correct that Exhibit P9 does not appear any other signature except the signature of Mrs. Jano and Mrs. Lilly. Then next paragraph, Your Lordship. I don't know the dates concerning handing over money by my husband, plaintiff, for making payment towards the loan. Then the last paragraph. I do not know whether the amount of rupees 50 lakhs were entirely transacted by issuing check and or some other portions being paid in cash. However, I know the entire amount should be rupees 50 lakhs. So this 50 lakhs, there is no dispute. Now, even with regard to 20 lakhs, there is no dispute. Next page, Your Lordship. On 3/11/06, I was present when the loan amount was enhanced to rupees 70 lakhs. Order, my lord. Para 11 of page 106. Para 11. I agree to the suggestion that the loan could not be liquidated within the stipulated time, that is 14/1/07, due to financial problem in my husband's business. Thereafter, the time for recovery of loan was further extended. Then at page 107, the first paragraph of re-examination on cross. On 3/11/06, when the loan amount was enhanced from rupees 50 lakhs to rupees 70 lakhs, I was physically present at the decision of the defendant with the plaintiff number 2. Then at page 108, yes, on the recross, first paragraph, it is correct that the plaintiff number 2 agreed to the enhanced amount to rupees 20 lakh in the mortgage deed on 3/11/06. So, my lord, now the question of 50 lakh, there is no dispute. With regard to 20, they were disputing. But the statement of the plaintiff, both the plaintiffs and the witness, that is the PW1, who is the wife of the plaintiff number 1.
So you're saying that that 20 lakhs also has been proved by the evidence of PW?
Yes. So another leg of argument advanced by my learned senior counsel of the appellants is that the said mortgage deed is not registered and is not valid. Now, as per Indian Registration Act, sorry,
Indian registration.
Section 17. Section 17 provides for documents of which registration is compulsory.
Yes.
Now, the present mortgage deed, since it is only a deposit of title deed, the registration is not required. Your Lordship, in this connection, I have a citation of the Apex Court. Which is reported in 2014 on SCC, page 105. Which is reported in 2014-1 SCC, page 105, in the case of State of Haryana and others versus Darveer Singh and another. My lord, the
Relevant portion is at page 111, para 14.2. But the question is whether a mortgage deed by deposit of title deeds is required to be done by an instrument at all. In our opinion, it may be effected in a specified town by the debtor delivering to his creditor documents of title to immovable property with intent to create a security thereon. No instrument is required to be drawn for this purpose. However, the parties may choose to have a memorandum prepared only showing deposit of title deeds. In such a case also, registration is not required.
This continue at 2.
Oh, all right.
May I please, Your Lordship?
Yes.
There is a matter, Your Lordship, is item number 37. Actually, the matter was listed in the e-court service yesterday. We came from Gauhati on Sunday, but after coming here, we came to know that it was strike out. So can this matter be upgraded in the second half in this matter?
May I please, Your Lordship?
They are also waiting.
Item number 33 and 36. I pray that this matter be listed as a fixed item on Monday, Lordship, that is 16.
30,
So that their matter may be up.
33 and
36.
36.
35.
35, okay. Just write down 33 and 35 on Monday. That is
As a fixed
16.
item.
16. Okay. And 37, you are for 37?
37.
37. Yes, it will automatically come after
Yes,
this matter.
in that case, there are 2 items are mentioned, obliged.
That earlier case you were reading from paragraph?
Paragraph 14.2.
14.2.
14.2 and 14.4. Now, Lordship at para 14.4, which is at page 112.
Yes.
Nothing has been brought on record to show existence of any instrument which has created or extinguished any right or liability. In the case in hand, the original deeds have been just deposited with the bank. In the face of it, we are of the opinion that the charge of mortgage can be entered into revenue records in respect of mortgage by deposit of title deeds, and for that, an instrument of mortgage is not necessary. A mortgage by deposit of title deeds further does not require registration. Hence, the question of payment of registration fee and stamp duty does not arise. My Lord, the mortgage is done by your deposit of title deeds. So, as such, registration is not necessary and it is valid. Your Lordship, another aspect of the matter is that the execution of the mortgage deed is not disputed. It is not under dispute. So, the question of raising objection is been stopped by the law of promissory estoppel, principle of promissory estoppel, which is which a party
where the documents produced are admitted by the signatories thereto and thus marked as exhibits, held no further burden to lead additional evidence. My Lord, in this aspect, I would like to cite a decision of the Apex Court, which is reported in 2003, volume 8.
Page?
At page, it is 745. The relevant para is para 16 and 17.
Yes.
My Lord, sorry, I'm just sorry. It should be 2003, volume 2. Sorry. Reported in.
You're not referring to this one?
That I'll come for another aspect. This is the principles of promissory estoppel. Para 13 and para 30, reported in 2003, volume 2, SEC, page 355. At para 13, at page 363. Estoppel is a rule of evidence, and the general rule is enacted in section 115 of the Indian Evidence Act 1872, in short, the Evidence Act, which lays down that when one person has, by his declaration, act or omission, caused or permitted another person to believe a thing to be true and to act upon that belief, neither he nor his representative shall be allowed in any suit or proceedings between himself and such persons or his representative to deny the truth of that thing. In para 30. Which is at page 370. If a man, either by words or by conduct, has intimated that he consents to an act which has been done and that he will not offer any opposition to it, although it could not have been lawfully done without his consent, and he thereby induces others to do that which they otherwise might have abstained from, he cannot question the legality of the act he had sanctioned to the prejudice of those who have so given faith to his words or to the fair inference to be drawn from his conduct. So, my Lord, this mortgage deed was executed with the consent of the plaintiffs. Now I'll refer to the other decision that is reported in 2003, 8 SEC, page 745. at para 16 and 17. Para 16 at page 751. Yes. Reliance is heavily placed on behalf of the appellants on the case of so-and-so. The legal position is not in dispute that mere production and making of a document as exhibits by the court cannot be held to be a due proof of its content. Its execution has to be proved by admissible evidence, that is, by the evidence of those persons who can vouchsafe for the truth of the facts in issue. The situation is, however, different where the documents are produced. They are admitted by the opposite party. Signatures of them are also admitted, and they are marked thereafter as exhibits by the court.
We find no force in the argument advanced on behalf of the appellant that as the mark of exhibits has been put on the back portion of the rent receipt near the place where the admitted signatures of the plaintiff appear, the rent receipts as a whole cannot be treated to have been exhibited as admitted documents. Para 17. We have already reproduced above the contents of order number so-and-so, dated so-and-so of the trial court. The appellant cannot be allowed to question the correctness of the said order. The documents were admitted and then exhibited. The plaintiff did not dispute his signature on the back of them. There was therefore no further burden of proof on the defendant to lead additional evidence in proof of the writing on the rent receipt and its due execution by the deceased landlady. So, my lord, here the question of the mortgage deed that is not under dispute. The executant, that is the plaintiff number 1 and number 2, they clearly admit. So, there cannot be any dispute with regard to execution of the said mortgage deed. And as already pointed out to your lordship that the mortgage deed is not required to be registered, as such it is valid document. Now, the second leg of argument that was advanced by my learned senior counsel, that is with regard to pre-suit interest. Now, the argument was that no prayer was made in the counter claim.
Yes.
Now, I would like to take your lordship to the counter claim, which is at page 49. At page 49 of the paper book.
Yes.
Yes, para 14. My lord, this is the written statement. This is the written statement. Para 14.
This is the
Written statement of the defendant.
Okay.
At para 14, it is very clear, may I read? Para 14 at page 449.
Yes.
That with regard to the statements made in paragraph 13 of the plaintiff, the answering defendant states that the amount due to the defendant from the plaintiff is as follows. Principal mortgage amount on rupees 70 lakhs, interest amount from 130506 to 31106, that is 5.5 months on 50 lakhs at 88%, 22 lakhs. Interest from 31106 to 030608, 19 months at 6%, 79 lakhs 80,000. Amount received on 220208, an extra 6 of the plaintiff, rupees 40 lakhs. Balance due till 040608, rupees 1 crore 31 lakhs 80,000. The plaintiff has so far paid rupees 40 lakhs to the defendant, and the balance due is rupees 1 crore 31 lakhs 80,000 payable to the defendant, and any other figure and liability presented by the plaintiff is employed to divert the issue to avoid repayment. Now, coming to page 151, counterclaim. This is the counterclaim. So the relevant prayer is at page 53. Para 41, page 53. Para 41. Prayer A. A decree for a sum of rupees 1 crore 31 lakhs 80,000, so and so only, that is capital rupees 70 lakhs plus rupees 61 lakhs 80,000, that is interest and interest penalty, or a decree for closing the mortgage. So, Lordship, this is the decree which has been prayed, which is inclusive of the capital as well as the interest, pre-suit interest. It is inclusive. So, my Lord, it is already in the prayer.
You are denying the payment of that 12 lakhs, no?
I'm coming to that.
Okay,
Yes.
okay.
I'm coming to that. So this is the prayer in the counterclaim. So pre-suit interest is also claimed by the defendant in the counterclaim. Now, Your Lordship, this is my claim, but what the trial court decided, that aspect is required. Trial court has considered my claim for this pre-trial interest, pre-suit interest.
Pre-suit interest.
Yes, at the rate of 14%. As per Nagaland's Money Lender Act 2005. Your Lordship, at the Money Lenders Act 2005, which is at, in the Nagaland Court, Volume 7, it is at page.
No, but do you have a license under the Nagaland Money Lenders Act?
Lordship?
Do you have a license?
No, I'm coming to that also, on that point. At Section 7, which is at page 296, interest and charges allowed to money lender. Subsection 1, no money lender shall charge interest on any loan advanced, whether on a pledge or otherwise, at a rate exceeding more than 3% above the prevailing average bank rate of interest on loans advanced by it. And subsection 2, the rate of interest shall be per annum simple interest on the principal amount of the loan. So, Your Lordship, at the relevant time, when this matter was decided by the trial court, at that relevant time, the then interest rate for commercial transaction was 11%. So by adding another 3%, it has been awarded 14%. Now section...
Bank interest was 11%.
Yes. Your Lordship, Section 27. Now, to answer the question with regard to license, this is relevant section. Section 27 at page 314. Contracts not to be void on account of offense. Your Lordship, if the person does not have license, he may be liable for the offense under this act. But the contract is not void on account of offense. May I read the contents, Your Lordship? Where a money lender is guilty of an offense punishable under this act, any contract of pawn or other contract made by him in relation to his business of money lending shall not be void by reason only of that offense, nor shall he by reason only of that offense lose his lien on or right to the pledge or his rights to the loan and the interest and other charges, if any payable in respect thereof. Though my claim of interest was per month, 6% per month, that was not considered as per my counterclaim. However, the trial court took cognizance of this provision of the Nagaland Money Lenders Act and awarded me this interest at the rate of 14% from the date of execution of the loan, that is 13/5/2006, till the recovery of the decreed amount. So, Your Lordship, now this act is a special act. So, with regard to special act, the decision of the Apex Court reported in 2011, volume 2, 12 SCC, at page 518, in the case of State of Rajasthan and another versus JK Synthetics Limited and another. I'll take Your Lordship to the relevant para, that is para 23 of the said judgment. Report this thing which is at page 527.
Yes.
Para 23, yes. It is therefore evident that whenever there is an interim order of stay in regard to any revision in rate of tariff or tariff, unless the order granting interim stay or the final order dismissing the writ petition specifies otherwise, on the dismissal of the writ petition or vacation of the interim order, the beneficiary of the interim order shall have to pay interest on the amount withheld or not paid by virtue of the interim order. Now, this is the important line, Your Lordship. Where the statute or contract specifies the rate of interest, usually interest will have to be paid at such rate. Even where there is no statutory or contractual provision for payment of interest, the court will have to direct the payment of interest at a reasonable rate by way of restitution, while vacating the order of interim stay or dismissing the writ petition unless there are special reasons for not doing so. Any other interpretation would encourage unscrupulous debtors to file writ petitions challenging the revision in tariffs, rates, and makes attempts to obtain interim orders of stay. If the obligation to make restitution by paying appropriate interest on the withheld amount is not strictly enforced, the loser will end with a financial benefit by resorting to unjust litigation, and the winner will end up as the loser financially for no fault of his, be that as it may. My Lord, there's a specific statute. The statute provides that interest can be charged over 3% over the bank interest, prevailing, the then prevailing interest. Though I have not filed cross appeal, my claim before the trial court was more than 14%. But since I have not filed any cross appeal, I have to be content with the decision of the trial court. Now, in another decision which is reported in 2007, which is with regard to award of interest. 2007, volume 3, SCC, page 545, in the case of Alok Shankar Pandey versus University of India and others. The relevant para is para 8 and 9. We are of the para 8, we are of the opinion that there is no hard and fast rule about how much interest should be granted, and it all depends on the facts and circumstances of each case. We are of the opinion that the grant of interest of 12% per annum is appropriate in the facts of this particular case. However, we are also of the opinion that since interest was not granted to the appellant along with the principal amount, the respondent should then, in addition to the interest at the rate of 12% per annum, also pay to the appellant interest at the same rate on the aforesaid interest from the date of payment of installments by the appellant to the respondent till the date of refund to this amount, and the entire amount mentioned above must be paid to the appellant within 2 months from the date of this judgment. Para 9. It may be mentioned that there is misconception about interest. Interest is not a penalty or punishment at all, but it is the normal accretion on capital. For example, if A had to pay B a certain amount, say 10 years ago, but he offers that amount to him today. Then he has pocketed the interest on the principal amount. Had A paid the amount to B 10 years ago, B would have invested that amount somewhere and earned interest thereon. But instead of that, A has kept that amount with himself and earned interest on it for this period. Hence, equity demands that A should not only pay back the principal amount, but also the interest thereon to B. Your Lordship, another decision where interest on interest and compound interest was awarded. That is reported in 2011, volume 8. Page SCC, page 161, which is reported in the case of, which was held in the case of Indian Council for In Viro Legal Action versus Union of India and others.
This is also an interest.
Interest on interest and compound interest. At page, Your Lordship, 161, the relevant para is at para 177, which is at page 241. Para 177. May I read, Lordship? Para 177. This court in Alok Shankar Pandey and Union of India observed as under the previously cited decision. Para 8. We are of the opinion that there is no hard and fast rule about how much interest should be granted, and it all depends on the facts and circumstances of each case. We are of the opinion that the grant of interest of 12% per annum is appropriate in the facts of this particular case. However, we are also of the opinion that since interest was not granted to the appellant along with the principal amount, the respondent should then, in addition to the interest at the rate of 12% per annum, also pay to the appellant interest at the same rate on the aforesaid interest from the date of payment of installment by the appellant to the respondent till the date of refund on this amount, and the entire amount mentioned above must be paid to the appellant within 2 months from the date of this judgment. Para 9, it may be mentioned that there is misconception about interest. Interest is not a penalty or punishment at all, but it is the normal accretion on capital. Para 178, this is compound interest. To do complete justice, prevent wrongs, remove incentive for wrongdoing or delay, and to implement in practical terms the concepts of time value of money, restitution and unjust enrichment noted above, or to simply levelize. A convenient approach is calculating interest. But here, interest has to be calculated on compound basis and not simple, for the latter leaves much uncalled for benefits in the hands of the wrongdoer. Para 179. Further, a related concept of inflation also to be kept in mind, and the concept of compound interest takes into account by reasons of prevailing rate. Both these factors, that is use of money and inflationary trend as the market forces and predictions work out. Your Lordship, now the third line of argument was that the enforcement of Usurious Loans Act 1918. So in this regard, my respectful submission is that since the money lenders, Nagaland Money Lenders Act of 2005 that has been passed, it is a special law, whereas the Usurious Loans Act is a general law. So, my Lord, when there is a special law, the special law prevails over the general law. So, my contention is that
first we have to see whether the Money Lenders Act will apply or not.
No, that's why. So, that is my contention. So, my submission is that since Nagaland Money Lenders Act and this Usurious Loans Act is with regard to loan, so it covers the same subject in the same field. So in this connection, my lord, I would like to cite a decision concerning the special law, which is reported in 2014, 8 SCC, page 319, in the case of Commercial Tax Officer Rajasthan versus Binani Cements Limited and another. The relevant para is at para 34, 35, and 36.
Para 34.
Para 34, 35, and 36.
36.
The para 34 is at page 332.
332. Yes.
Yes, merit. Para 34. It is well settled that when a general rule and a special law dealing with some aspects dealt with by the general law are in question, the rule adopted and applied in one of the harmonious construction whereby the general law, to the extent dealt with by the special law, is impliedly repealed. This principle finds its origins in the Latin maxim of generalia salibatia non derogant, that is, general law yields to special law should they operate in the same field on the same subject. This is reported in so and so, so and so, so and so. Para 35. Generally, the principle has found vast application in cases of there being two statutes, general or specific, with the latter treating the common subject matter more specifically or minorly than the former. Corpus juris secundum, so and so, states that when construing a general and a specific statute pertaining to the same topic, it is necessary to consider the statutes as consistent with one another, and such statutes therefore should be harmonized, if possible, with the objective of giving effect to a consistent legislative policy. On the other hand, where a general statute and a specific statutes relating to the same subject matter cannot be reconciled, the special or specific statute ordinarily will control. The provision more specifically directed to the matter at issue prevails as an exception or qualification of provision which is more general in nature, provided that the specific or special statute clearly includes the matter in controversy. Para 36. The maxim generalia specialibus non derogant is dealt with in volume so and so, so and so, so and so, as follows. The principle descends clearly from the decisions of the House of Lords in Seward versus Veracruz and the Privy Council in Barker versus Edger, and has been affirmed and put into effect on many occasions. If Parliament has considered all the circumstances of and made special provisions for a particular case, the presumption is that a subsequent enactment of a purely general character would not have been intended to interfere with that provision. And therefore, if such an enactment, although is inconsistent in substance, is capable of reasonable and sensible application without extending to the case in question, it is prima facie to be construed as not so extending. The special provision stands as an exceptional provision upon the general. If, however, it appears from a consideration of the general enactment in the light of admissible circumstances that Parliament's true intention was to establish thereby rule of universal application, then the special provision must give way to the general. Your Lordship, now the fourth lack of submission with regard to Section 34 CPC, which has been placed by my learned friend. He has Lordship may kindly turn to section 34 of CPC. He has just referred subsection 1. But now the important part is the proviso, which is just where I read the whole thing. Section 34, interest. Subsection 1, where and insofar as the decree is for the payment of money, the court may in the decree order interest at such rate as the court deems reasonable to be paid on the principal sum adjudged from the date of the suit to the date of the decree, in addition to any interest adjudged on such principal sum for any period prior to the institution of the suit, with further interest at such rate not exceeding 6% per annum as the court deems reasonable on such principal sum from the date of the decree to the date of payment or to such earlier date as the court thinks fit. Now, the proviso is, this is not applicable in the case, in the same case. The proviso, that is the subsequent this thing, provided that where the liability in relation to the sum so adjudged had arisen out of a commercial transaction, the rate of such further interest may exceed 6% per annum, but shall not exceed the contractual rate of interest, or where there is no contractual rate, the rate at which monies are lent or advanced by the nationalized banks in relation to commercial transactions.
No, but this was not a commercial transaction.
No, Lordship, as I've already referred, the loan was taken by the plaintiff for the purpose of his business. So it is purely commercial. So, my Lord, this is the provision, and in support of this contention provision, I would like to cite a decision of the Apex Court, which is rendered in the case of Punjab and Sindh Bank versus Allied Beverage Company Private Limited and others, reported in 2010, volume 10, SCC, page 640. The relevant para is para 20. Para 20 is at page 649. May I read, Lordship? Yes, para 20. By drawing our attention to the decision of this court in Syndicate Bank versus Mohan Bros, it is contended that in view of the proviso to section 34(1) CPC, if the liability in relation to the sum adjudged had arisen out of commercial transaction, the rate of such further interest may exceed 6% per annum but shall not exceed the contractual rate of interest, and the bank is entitled to claims interest as per contract. It is true that in this decision, there are 3 judge bench after finding that the decision in Central Bank of India case shows that no reference has been made to the proviso which specifically deals with the awarding of interest arising out of commercial transaction, referred the issue to a larger bench. We are not informed about any decision by a larger bench contrary to the decision in the Central Bank of India, even otherwise, considering factual aspects. Even the company agreed for settlement, but it was not successful due to financial difficulties and all other circumstances. We feel that the High Court has fairly neutralized the claim of the bank as well as the sufferings of the company and passed a workable order by reducing the rate of interest to 14% per annum, which would be simple interest in the day, interest in the respect of period, penalty and future interest, and effect from 4/7/2003, the day on which the bank filed an application before DRT. Though request was made by the company for such further reduction up to 12% per annum, since it was a commercial transaction and the bank, being a nationalized bank, we are not inclined to accede to their request. My Lord, here it is specifically decided that the contractual rate. But yes, in my case, since the contractual rate was not granted, at least the bank rate that was granted by the trial court. So that is, I feel it is justified, since I have not filed any appeal against the said decision. Your Lordship, now, the question now is regarding the 12 lakhs. Yes, I'm coming to that.
Because two witnesses are there who also said that.
Yes. Your Lordship, this issue was raised introduced only after filing of the suit. And it has been allowed, incorporated in amended recast petition. Yes, in amended recast petition. Now, in the first instance, they were silent about it. Only after filing application for this thing, amendment, it was allowed by the trial court and it came into the amended recast plate. Now, the pertinent question
Yes.
Your Lordship may see from the exhibit. This particular annexure, this annexure 3, which is at page 42 of the paper book.
Yes.
Yes. This has not been exhibited and marked. That is one aspect of the matter.
Not exhibited.
Yes. Though it has been annexed, it has not been exhibited, except the exhibit is with regard to the signature of the PW3 and PW9. Now, Your Lordship may kindly allow me to refer to that receipt. Sending Mrs. Lilly and Mrs. Dano to Kavi Muru and Society with interest for 3 months, that is from 13 May 06 to 13 August 06, rupees so and so, so and so. Now, the witness number 3, PW number 3 and PW 9, this question was put: who is the author of this receipt? They don't know. I'll refer to the relevant portion. The statement of PW9, which is at page 138. At page 138 of the paper book.
Yes.
The relevant portion is from the bottom. It is on the third from the bottom. I do not remember who prepared money receipt dated so and so, exhibit P9. However, the signature bearing serial number so and so belongs to me. I am certain that the said money receipt so and so was not by the defendant. And next page. The relevant one is at para 3, third para, page 39, 139. I deny the suggestion that the money receipt exhibit P9 was prepared by me, Mrs. Lee, the wife of plaintiff number 1, only after institution of the presence. So, Lordship, it has not been prepared by PW3, nor by PW9, nor by PW1. So who is the author of this receipt, money receipt? Now, that has not been produced by the plaintiff.
nominee receipt, you said it was not exhibited, but here she has said exhibit B9.
It is, they have stated, but the question, it is not marked as it is visible on the record. Even in the exhibit, in the contents page of this paper book, it has not been shown as exhibit, which is at second page of the paper book.
Okay, we'll see. The original records are here, no? We'll check out. Okay.
So now, Lordship, I would like to cite a decision of the Apex Court with regard to this thing inadmissible evidence, which is reported in 2009, volume 9, SCC, page 221, in the case of Malay Kumar Ganguly versus Dr. Sukumar Mukherjee and others. The relevant para is para 37. Which is at page 250, para 37.
Yes.
May I read, Lordship? It is true that ordinarily, if a party to an action does not object to a document being taken on record and the same is marked as an exhibit, he is stopped and precluded from questioning the admissibility thereof at a later stage. It is, however, right that the document becomes inadmissible in evidence unless the author thereof is examined. The contents thereof cannot be held to have been proved unless he is examined and subjected to cross-examination in the court of law. The document which is otherwise inadmissible cannot be taken in evidence only because no objection to the admissibility thereof was taken. No, yes. Now the fifth leg of argument, which was with regard to PW4, with regard to PW4, that is with regard to payment of rupees 10 lakhs on 2108. Your Lordship, I'll take your Lordship to first to the plaint, copy of the plaint, para 8 at page 29. May I read the first paragraph on the page 29?
Yes.
Thereafter, on 20/01/08, the plaintiff number 2 paid an amount of rupees 10 lakhs only to the defendant in the presence of Mrs. Imotila and Mrs. Alin Mongla. This is one of the statement in plaint of the plaintiffs. Now, in the statement of the plaintiff number 1, which is at page 74. Para 8, page 74, para 8. That on 20/01/08, the plaintiff number 2 further paid an amount of rupees 10 lakhs, only to defendant in the presence of Mrs. Imotila and Mrs. Alin Mongla. This amount of rupees so-and-so was paid by me to the plaintiff number 2 through my wife. This is the statement of the plaintiff number 1. Then at page 78, para 26. Lordship, the relevant portion is at page 79. Page 79.
This is whose
The statement of plaintiff number 1. Toshi Pogba.
Okay. Continuation, no?
Yes, continuation. The plain, what has been stated in the plain, he has stated in this statement also. So the first line, after received rupees 5 lakhs against the loan on
21.
On 20/01/08 when the defendant received rupees 10 lakhs. Now another relevant statement of the plaintiff number 2 at page 87. It's page 87. At page 87, para 7.
This is plaintiff.
Yes. That on 20/01/08, Mrs. Lamu, wife of plaintiff number 1, handed over an amount of rupees 10 lakhs to me for repayment against the loan. Accordingly, I, along with Mrs. Imotila and Mrs. Aril Mongola, went to the residence of the defendant and handed over the amount to the defendant. My Lord, why I am referring to this statement is that I'll come to the relevant issue. Then at page 92, para 25, in the cause of action. Para of action 1, 2, 3, 4, 5, 6, 7, 8. 11 line on the right hand side. On 20/01/08, when the defendant received rupees 10 lakhs.
Yes, 21.
So this is plaintiff number 2. In his statement, in his examination in chief. Page 92.
Okay. So it is telling that on 21/08.
I'm coming to that relevant portion.
Okay.
And at page 102. At page 102, at para 8. Para 8. That on 20/01/08, I handed over his 10 lakhs to Mrs. Imotela, the younger sister of the plaintiff number 1, asking her to hand over the amount to the plaintiff number 2. So, Lordship, this is the statement of the plaintiff number 1, number 2, and PW number 1. Now, I'll come back to PW number 4, which is at page
PW4.
PW4. She is the Imotila. At page 118. Para number 3.
Yes.
Yes, this is that on 21/01/08. So the date which has been emphasized by the plaintiffs, the witness number, PW number 1, is 20/01/08, whereas this witness, as per our statement in examination in chief, this is in examination in chief, 21/01/08. Now in the close examination, Your Lordship, at page 120. Yes, this is the statement of cross-examination of the
PW4.
PW4. Your Lordship, from paragraph 2, the date is 21/1/08, paragraph 2, then paragraph 3 also 21/1/08, then the paragraph 4, I met the defendant for the first time on 21/1/08, then paragraph 5, on 21/1/08, the plaintiff number one's wife was not feeling well. As such, I was interested to hand over the money to plaintiff number 2. This was the same date, 21/1/08. Then the next date is in the second last paragraph from bottom. I have not met the defendant after 21/1/08. Then the last paragraph, I denied the suggestion that Mrs. Aren Mola was not with me and the plaintiff number 2 when the said sum of rupees so-and-so was paid to defendant number 1 on 21/1/08. Then next page, Your Lordship. The relevant portion, the fifth paragraph. On 21/1/08, the plaintiff number was out of station. Then the next paragraph, I do not remember the exact time of my visit to the defendant's place on 21/1/08. However, it may be around 2 to 2:30 p.m. Then in the re-examination, the above statements were on cross-examination. Now on re-examination, it is correct to state that on 21/1/08, then the next paragraph also, same date is 21/1/08. Now, plaintiff in their plaintiff number 1, number 2, in their statement, in the same 21/08, in their statement, in examination chief, it is 20 January 2008. PW1, who is the wife of the plaintiff number 1, in her statement, it is 21/08. Now, this witness,
PW4.
21/1/08.
But can that be very fatal because the rest of the story is the same?
No. That's why now another question, because now she is alone here now. She is already against the plaintiffs. Her statement is against the plaintiffs. Now the appellants, they want to assert that another witness has testified the same in support of the witness number 4. But that is the wrong submission. It will be on record of the lower court that the PW number 6, though her statement in the examination chief that has been already there, but she was dropped. She was not examined.
PW6 was.
Yes. On the earlier occasion, my learned friend has submitted that she was not examined, but it was not that she was dropped by the plaintiffs. So now, the witness of the plaintiff, PW4, has not supported the statement of the plaintiff and the PW1.
No, only the date is not telling.
No,
otherwise, she also said that she also went along with plaintiff number 2 and went to the residence of the defendant.
But that is, Your Lordship,
the
the date is...
plaintiff 2 who handed over the sum of 10 lakhs.
The date is very important because the question is that here in my case, in my stand is that I have not received anything. So that is very important for me. Because the statement of the plaintiff that is not supported by the material witness that with PW4. PW1 supports the plaintiffs, but PW4 does not support the plaintiff as well as the statement of PW1. So, Your Lordship, this is my contention that these are all concocted and false statements. Now, with regard to the draft account, which is at page 44 of the paper book,
Yes. This one which was supposed to be left by you.
Yes. Now, this was at the instance of the plaintiff. This was subjected to examination by the handwriting expert. And the said author of Annexure 6, the writer of Annexure 6, his handwriting was compared with this rough record. However,
Handwriting of PW.
no, actually he has been produced as a court witness.
Oh, okay, okay.
Yes.
He was that Gambura.
No, he was
Which one was
some
this?
in-law of the defendant.
Okay.
Yeah.
Okay.
So since this Annexure 3 was written, he was the writer of this Annexure 3. So the plaintiff's contention was that this was also prepared by the same writer, Annexure 5.
So Annexure 3 and Annexure 5
Yes.
were compared.
So your Lordship will kindly see page 150. 150 and page 151.
Page 151.
Yeah, this is the document which was sent to the Forensic Science Lab, Gauhati, at page 150. Then this page 151 also. Then he was made to write in the court. So this page 152 is the one which he wrote in the court. And page 153 also, it was written as per the direction of the court. And these documents were sent to the FSL. So the opinion, actually here, the relevant portion of the opinion which was submitted to the court, that is not in the paper book. However, the order of the court, which is at page 157, page 157, that has been the opinion which has been submitted by the FSL, it has been recorded by the court that no definite findings could be arrived. Now,
But the FSL also said something to send some more documents.
yes, sir, that was not done.
Yes.
Because it was not possible to get the writing of the concerned person during that period. Because their request was that to send his writing
At that time.
That was in 2008.
So it was not conclusive.
Yes. So, Your Lordship, now since the expert could not come into any conclusive finding, and the author, that means in other words, the author of the said rough account could not be ascertained. So, unless the author of the document is examined and subjected to cross-examination before the court, otherwise it has no relevancy and it is inadmissible as per the decision which I have already cited earlier. Your Lordship, another aspect of the matter which is relevant for examination of this honorable court. In my written statement at page 49, para 16, at page 49, para 16. That with regard to a statement made in paragraph 16 of the plaintiff, it is stated that the plaintiff, through his relatives, asked to settle the debt by paying a lump sum amount of Rs 65 over and above 40 lakhs already paid, after utilizing the defendant's money for about 2 years. However, the defendant could not accept the offer as the defendant could not meet the interest he owed to the lender to whom he borrowed to lend the plaintiff. So, this is one aspect of the matter. After payment of this 40 lakhs, which the defendant clearly admits, the further approach was from the relatives of the plaintiff that to settle the issue on receiving 65 lakhs. That was not accepted. So, against this particular statement, the defendant, the plaintiffs, they have not filed any replication or rejoinder. So, my submission is that this shows that the plaintiffs, they owe money to be paid to the defendant.
No, they are also not denying.
No, that's why. That's why.
It's only the figures are not
it is not that. Actually, my learned friend has confined his argument on specific line. Otherwise, their claim is that they have overpaid to me. They have paid 1 crore. That is
They
their.
have paid 160.
Yes. Yes. But, so their claim is that they have overpaid. I have to refund to them. That is their case, actually. But since due to lack of evidence, now my learned friend is confined to 62 lakhs. 40 plus 10 plus 12.
Yes.
No, that's why.
40 plus 10 plus 12.
Yes. Yes, he is confined to, that's why. That's why I'm also just confining on that, this thing, arena. Otherwise, as per their plaint, it is different. So, Your Lordship, my
Let us see their prayer.
No, okay, I'll explain.
In the plaint.
Yes. Yes.
For the purpose of adjusting the amount of 1 crore 60,000. Already paid by the plaintiff to the defendant. And thereafter to direct the defendant to refund the excess amount. It is okay. To declare the mortgage deed as illegal, unlawful, then to hand over the possession of the original Jamabandi, then to reopen the accounts for the purpose of adjusting the amount of 1 crore 60,000. Okay.
So, since my learned friend is confined to certain arena, I'm also placing my argument on confining to that submission. So my respectful submission is that basing on all these aspects before the trial court has rendered a judgment decree. Since I have not filed any appeal now, I'm not complaining against the no complaint against the judgment and decree. But Your Worship, one aspect for interference of this court in the matter, unless it is vitiated with serious infirmity or committed any error of law or procedure resulting in perverse conclusion. So I would like to cite in this regard one decision which is reported in 2013, volume 10 SCC, page 192, in the case of Hema versus State through Inspector of Police Madras.
This is on what point? Interference
This is
in appeal?
reappraisal of evidence. The relevant para is at para 32. Though this case is decided in the criminal side, but the law of evidence is applicable in both criminal as well as civil. Para 32, which is at page 208. In the light of the overwhelming evidence placed by the prosecution, analyzed by the trial court and affirmed by the High Court, interference by this court with concurrent findings of fact by the court below is not warranted except where there is some serious infirmity in the appreciation of evidence and the findings are perverse. Further, this court will not ordinarily interfere with the appreciation of evidence by the High Court, and reappreciation is permissible only if there is an error of law or procedure and conclusion arrived at are perverse. So, my Lord, my respectful submission is that the trial court has marshaled the evidence on record and arrived to the said finding and decided the matter by passing the impugned judgment and decree dated 31/3/2014. So, Your Lordship, now one aspect which I have just failed to mention earlier. Now, against the counterclaim of the defendant, the plaintiffs, they filed their return statement, which is at page 66.
Page 66. Yes.
My Lord, here in the return statement against the counterclaim, the appellants, they have not even questioned the prayer made by the defendant in this counterclaim for the capital amount as well as for claiming the accrued interest, pre-suit interest, and interest penalty, except it has questioned there is no right to apply for foreclosure of the alleged mortgage. Your Lordship, that will be my, if any clarification is required.
Yes, any reply?
Yes, Your Lordship, I try to finish as short as possible. First one is the respondent defendant has thoroughly misled the trial court and obtained the decree in his favor. First, Your Lordship, I would like to refer to the Nagaland Mandir Lenders Act, Section 27, as referred to by my friend. The court has been thoroughly misled by misinterpreting Section 27. Section 27 reads, contracts not to be void on account of offense. where a money lender is guilty. Now, Your Lordship, first, a money lender. This means a licensed money lender. A licensed money lender is guilty of an offense punishable under this Act. Under this Act, any contract or bond or other contract made by him in relation to his business of money lending, having a license, shall not be void by reason of only of that offense. Now, what can be the offense under this Act? Those we can see in foregoing paragraphs. Penalties. So, a person without having a license does not come under this section 27. This covers a person having a license but committed an offense under this Act, which may be charging more interest than mentioned in section 7, or not exhibiting their names over their shop, or during change of their business, their proper address, pawn ticket to be given to pawner, if not given, conditions relating to redemption of pledge, those things, those related offense. So, not an offense having operating money lending business without license. It is not covered by section 27. That is outside. Then the second point is, according to my learned friend, now since this Nagaland Money Lenders Act is a special act, the other Usurious Loans Act cannot be applied. Now, Your Lordship, what is Usurious Loans Act? Usurious Loans Act 1918, first one is, now first says, an act.
In any case, just for academic interest, this Money Lenders Act, is it actually applicable? Is it being applied? Because only last year, I think only last year inspectors were appointed.
Your Lordship,
only in 2025.
True, Your Lordship.
Yes.
There's a question.
Without inspectors being appointed, can this act?
The other point is, section 1 clause 3. It shall come into force on such date as the state government may, by notification in the official gazette, appoint. So, first, the governor assent is obtained and it was published in the gazette. But now to come into operative,
yes,
it has to be again published in the gazette.
Exactly.
So I'm not sure whether that's been done.
I don't think so.
Yes.
And inspectors were also not appointed.
Yes.
Only 2025 inspectors were appointed.
True, Your Lordship.
Yes.
So there is a doubt. Then users, even if that is applicable, assuming that the Nagaland Money Lenders Act is applicable, that will not override the effect of Usurious Loans Act 1918, because it says an act to give additional powers to courts to deal in certain cases with usurious loans of money or in kind. So, usurious loans is an additional power given to courts. Therefore, the Nagaland Money Lenders Act has no effect.
That is section?
That is the first sentence.
Oh, okay.
Yes, under usurious
the object
yes.
of the act.
Then the next is, assuming I'm being fair, I'm trying to be fair. Now, since there is no contractual agreement on valid interest, since that 6%, 8% was monthly, That cannot be applied under any circumstances. So I'll say that yes, the court at times may have the discretion to grant interest, pre-litigation interest or pre-suit interest, but that cannot exceed the rate of interest prescribed under the Interest Act. That will be current rate of interest of the nationalized banks. That has to be considered. So my friend says, at that point of time, there is 11%. From where they got it? Then they try to justify that 14% by taking the advantage of Section 7 of the Nagaland Money Lenders Act. So therefore, on that score alone, the impugned order cannot stand. Then mentioning something in the plain is different from evidence. Mentioning the rate of interest from the date of lending and money till up to date, including the interest for the period before filing the suit, although that may have been mentioned in the plaint. Now, plaint is different and prayer is different. Prayer has to be there in the plaint. What I'm emphasizing is that without a prayer, a specific prayer, the court cannot grant normally pre-suit interest unless there is compelling circumstances in the facts and circumstances of the case. Not generally the court cannot, and the court should not. Those things are the difference. Then, on finding of Exhibit 9, which is a receipt issued by PW 9 and 3, I explained that yesterday, that this is not a receipt issued by somebody else, but it is a receipt issued by PW 9 and 3 that we have received that money from there. And the trial court has not relied on this also in his findings. So there is no point in arguing this one. Then your Lordship will see, my friend has strongly emphasized on the question of rupees 20 lakhs, enhanced amount of 20 lakhs by relying on the cross-examination of the witnesses. Where's that one? First one is PW1, page 81, running page 81, para 8. My friend has referred to this para 8, cross-examination. In regard to enhancement of loan to the extent of rupees 70 lakhs and making necessary correction in the mortgage deed is done by the plaintiff number 2, and I was not present. Then, para 9, next page at page 82, it is correct to say, I do not know who received the enhanced amount of rupees 20 lakhs. So, what my friend is trying to say is that mentioning amount of rupees 20 lakhs is the end of the matter. That is 20 lakhs. Because the question is whether this is cash or check or whatever. It is not, the question was not put in that way. Now, next is, in re-examination of this witness at page 84, the witness says, page 84, the witness says, It is clarified that the initial loan amount of rupees 50 lakhs, however, subsequently 3 months defaulted interest of rupees 12 lakh, 8% per month was added to the original amount of rupees 50 lakhs and further making a cash payment of rupees 8 lakhs to the plaintiff number 2. Their principal amount was enhanced to rupees 70 lakhs. Why the trial court has not considered all these facts of the case, which is stated in re-examination. Then next one is page 94, PW number 2. Plaintiff number 2. In para 6, it is correct that I received for the loan of rupees 20 lakhs on 3/11/06 and accordingly to the mortgage deed dated 13/5/06 was amended by entering rupees 70 lakhs and interest at the rate 6%, which I acknowledge and signed on the said mortgage deed on 3/11/26. The question is not how much you receive in cash. Therefore, rupees 20 lakhs, he simply said yes, rupees 20 lakhs, because 12 lakhs was interest. Why I am emphasizing this is that if rupees 12 lakhs is compounded to the principal, then the court has granted interest upon interest. That is not permissible, except in certain cases. These other cases relied on by my learned friends. I don't know what, because I have not gone through. Now, grant of interest, if it is tried by an arbitrator, that is totally different. They are not bound by the section 34 of the CPC. They can exceed that one, if it is by arbitrators. Then, in other cases, whatever cases has been relied on by my learned friend, those are relating to all validly contract agreements. Whereas in the present case, there is no valid contract agreement. Just because a mortgage deed is alleged to have been executed by depositing of title deeds, that will not prove the deed itself. If we are to accept that argument, then we are accepting the charge of 8% and 6% monthly interest, which come to 92% and 72% and 96% per annum.
Per annum.
Yes. Therefore, the trial court has not accept saying that it is valid and enforceable. If it is enforceable, then monthly interest has to be enforced. There is no escape from there. But in such cases, usual loan side will come into play, interest act will come into play, which the court failed to do. Then, continuing with the PW plaintiff number 2, para 6, I have already decided. Now we can see in re-examination at page 98. Although he said 20 lakhs, now in re-examination, it is correct to say that on the subsequent mortgage deed dated 3/11/06, where the loan amount was enhanced from 50 to 70, I had received a cash amount of rupees 8 lakhs only, and rupees 12 lakhs, which is the defaulted interest, was compounded to the first principal loan amount of rupees 50, and thereafter the loan amount was enhanced to rupees 70 on 3/11/60. It is the trial court's duty to find out the truth. Who is telling the truth? How far the evidence can be relied upon? Whether there is any preponderance of probability that the court has to examine, in spite of denial of the defendant, because a denial is not final. It can be rebutted, it can be disproved. And in the present case, the plaintiff has disproved the denial of the defendant. And then in further re-examination at page 99, just above recourse, same statement by this
plaintiff too.
Plaintiff too. Then in recourse, now my friend will say that he has admitted, but in recourse, exhibit D13 is my signature, and I admit to the receipt of rupees 20 lakhs cash on 3/11/06 as written in exhibit D1. He is referring to exhibit D13. And in the exhibit D13, it is written rupees 20,000 cash. So he is admitting that yes, in that exhibit D13, it is written as rupees 20 lakhs cash. But in his examination and re-examination, he is clearly saying 8 lakhs cash and 12 lakhs interest compounded to the principal amount. And then similarly, Your Lordship, it is same with the 10 lakhs. Now, the court's duty, the trial court's duty is to see who is to ascertain the authenticity of the statement, the veracity of the witnesses. And therefore, the trial court thoroughly failed to carry out its duty. And grant of interest, no reason has been given why it should not be at the rate of 12-14%, pre-suit interest, post-suit interest still at the rate of 14%, without clarifying whether this is a loan for business or contract. If it is for a commercial purpose, that has to be there in the agreement itself. We cannot subsequently say, yes, this is for contract. We cannot. Election is not a contract. Election is not a business. The witnesses said, yes, it is for election, But that is not a business. Contract. What kind of contract? Those are general. So we cannot say that, we cannot presume in that circumstances that, yes, the money has been loaned for contract business or contract for business. Which contract? Which contract and what type of contract? So, in view of all those things, there are many more, but since time also is limited, and then I have taken a lot of time yesterday, the trial court has failed to carry out its function properly, justifiably, and it cannot be
so many discrepancies are there actually.
Yes.
And because here we do not follow the, money lending process is also just very casual.
Very random.
Very random.
Yes.
So
now, where is the defendant says this is Naga style? Can we enforce it in the court of law? Naga style. We don't have a Naga style. A Naga style is to go and lock the door, just like he did. Lock in my doors, lock in my gate. Until I paid rupees 10,000 on 21.
The main thing
06.
is, what I have gathered is, you are also admitting that you have borrowed some money.
Of course, I have borrowed some money.
But how much you have returned and how much he has received, that is the only issue.
Yes.
That is the only issue. And then another point is the interest.
Interest.
That is the interest. So that is actually basically these are the only things. The main crux.
Yes. That is not decided. That is
That
the
is
whole
not
pro-
been decided properly.
Yes.
That's what you're saying.
Your Lordship.
Okay.
So, that's
Anything
that's
more,
all.
Mr. Likam? I think that will do.
Your Lordship, I hope so.
Now,
It's already on record.
now it's up to me to go through all this, and the records also.
I think it's with the Lordship now.
Okay, just go. Acha, this one, na. Can you give written arguments?
Okay.
Written arguments, and then Luikam, these decisions, na. I don't want to take the whole book. So just the relevant para, if you can give a gist of your
okay.
your judgments and the relevant para, then they can print out the relevant para and give it to
Okay.
me. Okay. Okay, just go to the next case.
For hearing, item number 37.
Yeah, British Lordship.
Yes.
My Lord, because of the timing, my
Yes.
friends, they have left because they came from Gauhati.
Okay.
So we have a consensus prayer if this matter can be listed on 20th of April.
20.
20th of April.
Okay. Let them come first. Okay, first you write for item 31. Okay. Item 31, heard learned counsel for the appellant, senior counsel for the appellant, Mr. Ari Ralu. Also heard Mr. Enke Luikam for the respondents. Hearing is concluded, judgment reserved. Okay. Then item 37, you say on the consensus prayer made by the parties, list the matter on 2026 for hearing.
My Lord, here is an interim.
The interim order passed earlier shall continue till the next date.
Much
I leave more spread.
Item number 38.
Mr. Vito Zimomi. Vito. Pass over. Item 38, pass over for the day.